Madam Clerk, I'm ready.
Case number 2020-603, the state of Florida versus Sarah Boone, appearances of record state.
Catch-drawer on behalf of the state.
William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone, raise your right hand to be sworn, please. Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right, Ms. Boone is seated at counsel's table wearing a light gray suit and a white blouse. She is in custody, however, will not be wearing any restraints. As such, we will continue to stand when our jury enters and exits. We're here for a charging conference. The court has reviewed, I believe, both parties' red lines as to the jury instructions, including, I believe, that was submitted last night, the defense's red line as to the jury instructions that were provided by the court. Let's try to get as much done as we can until our jury arrives. I believe what we had discussed yesterday was starting at the beginning and moving through as quickly as possible until we get to the real meat of some of the issues in the 3.6F and the 3.6G instructions. Mr. J?
May I remain seated during the charge conference?
Yes, sir, you may. Thank you. All right. I have in my hand a 34-page document that was emailed to the court last night by counsel for the defense at 12:06 a.m. from Lauren Henderson. That's what the court's going to be relying on. Does everyone have that in front of them?
Yes, sir.
Defense.
And paces, yes, Judge, I do.
Okay, all right, let's start on page 1 of 34. 3.1, Introduction to Final Instructions. Any objection to the form of this instruction? State.
Now I'm confused. I don't know that I have a 34-page document from them last night. There was an attachment. There was an email at 12:06.
Hang on, let me make sure.
Attachments. 36F, separate red lines. 36G, separate red lines. 8.9, culpable negligence, red lines, separates.
Give me a moment. Then it was what was sent at 11:31 yesterday.
That 34-page document I have.
Okay.
Well, 31. I don't know if it's 34. It says 31 to me.
I have it as 34. Okay.
Excuse me, Judge.
Yes, sir.
Can I have Ms. Henderson explain how she sent the document?
Fine by me.
Your Honor, yesterday morning, 11:30, I sent the red line instructions from the defense based off the document you had sent to us yesterday morning. And then last night, we approached and I had asked if that format was okay for you. I believe Mr. J had said, could the defense send separate 3.6, 3.F, so it'd be easy to incorporate in your final instruction.
And that's what was sent at 12:05 last night. All right.
Just for more convenience for you.
Understood. Okay.
Thank you.
But the balance of the instructions, because that just addresses those. What you just advised only speaks to the 3.6, 3.6G instructions.
And F and culpable negligence.
Correct. Okay. All right. So I'm talking about the balance of the instructions that may or may not be at issue.
Yes, sir. That was the balance of instructions that are not at issue. Those are what was sent at 11:30.
Okay. All right.
My confusion is the court has indicated they have a 34-page document.
Yes, sir.
I have a 31-page document that was emailed to us by Ms. Ms. Henderson at 11:32 in the morning.
Are you looking at October 24 at 11:31 a.m.? Subject, defense proposed jury instructions in red line format?
I'm sorry, Mr.
No worries. I'm looking at the email correspondence of October 24, 2024, 11:31 a.m. Subject, defense proposed jury instructions in red line format. Is it possible that you don't have your track changes are off, and maybe that's why? That's the difference.
Where the track changes, please?
In Word, under review, or I can just have Madam Clerk print out 2 more copies. And we could just work our way through that.
I see track changes. But track changes for everyone is still only 31 pages.
Okay. I just forwarded to Madam Clerk. I'm gonna have her print out 2 copies. That way we've got hard copies, so we seem to be all on the same page. right, both parties have what was provided to the court yesterday, a 34-page document, which includes the defense's red line with regard to the proposed jury instructions. We'll start on page 1 of 34. Instruction 3.1, Introduction to Final Instructions. Any objection to the form of this instruction, State?
No, Your Honor.
Defense?
No, Your Honor.
Moving to page 2 of 34, Instruction 3.2, Statement of the Charge. State?
No objection.
Defense?
No objection.
Moving to page 3 of 34, 7.1, Introduction to Homicide. Those 3 paragraphs, any objection?
No objection from the State.
No objection.
Moving to the next portion, Justifiable Homicide in the singular paragraph. Any objection, State?
No objection.
Defense?
No objection.
Moving to Excusable Homicide and the 4 paragraphs, including paragraphs numbered 1, 2, and 3. State?
No objection. I have no objection to anything I submitted to the court.
Okay, thank you. Defense?
No objection.
Moving to page 434, 7.4, second-degree murder instruction. Defense, any objection to the form of the instruction?
No objection.
And also the removal of the lesser included chart on page 5 of 34, correct?
Correct.
Moving to page 6 of 34, instruction 3.4, when there are lesser included crimes or attempts. My only question is, if I understand from the defense, they're looking to see culpable negligence is a lesser included.
Yes, Your Honor.
Would that not need to be included here?
Yes, Your Honor.
Okay, so is the only addition to this the balance of the 3.4 instruction would be correct with the exception of the last sentence, which would read the lesser crimes, plural, indicated in the definition of second degree murder is manslaughter and followed by culpable negligence.
Yes, so it should go to R. Yes.
State?
State objects. There's no evidence to support a misdemeanor culpable negligence lesser included offense for a category 2 lesser to be included in the jury instructions. Both must be supported by the charging instrument as well as the evidence in the case. There is no evidence in this case that he only suffered culpable negligence. The crime for culpable negligence with death is manslaughter. Culpable negligence isn't even a category 1 lesser of manslaughter. It's a category 2 lesser, which includes, by inference, there must be some evidence that her culpable negligence did not result in death.
What's your response to that?
Judge, the instruction that we're asking for is 8.9. It reads to prove the crime of culpable negligence. The state must prove the following 2 elements beyond a reasonable doubt. 1, Sarah Boone exposed George Torres Jr. to personal injury. And 2, she did so through culpable negligence. As to the fact that there is evidence of culpable negligence as to the case, and the fact that Ms. Boone, while Mr. Torres is still in the suitcase, goes upstairs. As to it being charged, it's a category 2 lesser included that's available to the defense. The defense can get category 2 lesser included offenses as long as there's evidence to support the category 2, and there is evidence in this case to support the category 2 lesser included. That's
And
why we're asking.
any other further argument, Mr. J?
No, Your Honor. Thank you.
Okay, all right. At this point in time, the court is inclined to include the culpable negligence as a lesser included. We'll get to the instruction momentarily. Any other revisions to the 3.4 instruction? Defense?
No, Your Honor.
Moving now to 7.7 manslaughter, there are some objections. The defense is now objecting to paragraph 2C, the death of George Torres was caused by the culpable negligence of Sarah Boone. So how can you ask for a culpable negligence instruction and then object to 2C in the manslaughter instruction? Logically, having trouble understanding that.
This is my argument, because I'm not arguing that there isn't evidence of it, because I just said there's evidence of culpable negligence. The difference is, and I think the burden is different from the state, because it's not alleged in their information.
Does not the instruction say give 2A, 2B, and or 2C depending upon allegations and proof?
Yes, the allegations would be the information.
Okay. Any response, Mr. J?
Judge, it's a category 1 lesser. All the theories are included in that. The language does not need to be included in the charging instrument. And quite frankly, it's not inconsistent with the language in the charging instrument. She's accused of having a depraved mind when killing him, and what the evidence has also shown is that she was heavily intoxicated when she made this decision. That supports a conclusion for a prior fact to reach that this was out of culpable negligence, and if they reject our argument that it was done knowingly and out of hatred, ill will, spite, etc.
Any other argument, sir?
No other argument, Judge.
At this point in time, the court is going to overrule the defense's objection as to the objection to 2C in the manslaughter instruction, including the final 2 paragraphs of what the definition of culpable negligence is on the bottom of page 7 of 34. It seems like it's stipulated between the parties that 2B, Sarah Boone intentionally procured an act that caused the death of George Boone, should be George Torres, is not applicable. Is that correct, State? Is that correct, defense? Okay, thank you. And also, since 2B is not applicable, the to procure definition will not be provided. Any other questions regarding the 7.7 instruction?
No, sir.
No, Your Honor.
No objection to what they suggest is the definition of culpable negligence as the court's indicated.
With regard to the
Second lesser?
the second lesser? Yeah, thank you.
No objection to that proposed instruction.
All right, very good. Thank you very much. What is the instruction number for the culpable negligence instruction? I think it's 8.9, isn't it?
8.9.
Okay, thank you very much. Moving now to page 10 of 34, 3.6D, voluntary intoxication. Does this now need to address culpable negligence? Or is that only
Yeah, we would request to add it, the culpable negligence, since it's going to be given. So it should read second degree murder, comma, manslaughter, comma, or culpable negligence.
You're talking in the last sentence, correct? Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence.
Yes,
correct?
Your Honor.
Thank you. Any objection,
No,
defense?
I agree, Judge.
Thank you. Do we want to take an attempt to address the 3.6F?
I would suggest we do that later and see if we can just get not
This-
3.6 done.
At this time, we're just going to make a note that we're going to bypass the 3.6F instruction and 3.6G instruction. That'll take us all the way to page 23 of 34, instruction 3.7, plea of not guilty, reasonable doubt, and burden of proof. Any objection to the form of this instruction, defense?
No objection.
Moving now to page 24 of 34. Weighing the evidence, 3.9 instruction.
Should we go to 3.7, plea of not guilty?
Did I skip it?
Yes, sir. Page 23 of 34.
I'm sorry, I thought that's what we just covered, Mr. J. I apologize.
Oh, I didn't. I was just making sure that there were no edits that either the court made or the defense made, so I was scrolling, but no objection to 3.7.
Okay, thank you. Moving now to page 24 of 34, 3.9, weighing the evidence. Looks like give as applicable paragraphs 6, 7, 9, and 10 have been struck. Is that acceptable? State.
Yes, Your Honor, I agree that 8, the inconsistent statement instruction, should get bumped up to 6.
Agreed.
And the remainder should not be read.
With those revisions, is that instruction 3.9 acceptable to the defense?
Yes, Your Honor.
Okay. Moving now to page 25 of 34, the latter portion of the 3.9 instruction. Any objection to the language contained on this page, state?
No, sir.
Defense?
No, Your Honor.
Moving now, the 3.9A instruction was struck by virtue of Ms. Boone testifying in this matter, so that need not be addressed. The 3.9B defendant's statement instruction also included the requested language by the state. Is there any objection to the form of this instruction at this time, defense?
No, Your Honor.
Okay, Ms. Boone, earlier this week, and I can't recall if it was yesterday or the day before, the state had filed a motion seeking to add additional language to this instruction. And I had read that language to you at that time. Do you want me to read it again to you this morning?
Yes, please.
Okay, so I'm going to read you the entire 3.9B instruction. 3.9B defendant's statements reads, a statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get him to make it. That should be revised to the feminine. Any objection?
No, Your Honor.
Defense?
No, Your Honor.
That is the form instruction created by the Florida Supreme Court, ma'am. What has been added is the next paragraph, which reads, law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Similar to other conversations we've had this past week, ma'am, I don't want to know about specifics of any conversations that you had with you and your attorneys, just simply whether or not those conversations have been had. Did you and your lawyers discuss the proposed language that I just read to you?
Yes.
Do you have any questions with regard to that proposed language?
No.
Are you in agreement with this additional language being added to this defense?
Yes.
All right, thank you. Or to this instruction, rather. Thank you. The last sentence read, if you conclude the defendant's out-of-court statement, was not freely and voluntarily made, you should disregard it. Any other clarifications to that instruction state?
No, Your Honor. Thank you.
Defense?
Judge, in looking at it, it says in the final part, consider whether the defendant's statements, can we replace and put whether Sarah Boone's statements?
Where are we specifically, sir?
In the state special that I have no objection to, it says, this is, however, one of the factors you may consider whether the defendant's statements, and if we could have Sarah Boone's statements, were voluntarily made.
The language used all throughout the instruction is the defendant.
Yeah, I tend to agree with the state on that.
Okay.
Rule 3.10, or I'm sorry, instruction 3.10, rules for deliberation, page 28 of 34. Looks like the parties agree that paragraph 7 is not applicable.
Yes, sir.
I agree.
All right, that would change paragraph 8 to 7. Any other revisions to 3.10?
None.
Defense?
None from the defense.
Moving to 3.11, cautionary instruction. Defense?
No objection.
The court then interlineated on page 30 the 2.7 closing argument form instruction. Any objection to that instruction state?
No, Your Honor.
Defense?
No, Your Honor.
Moving now to 3.12 verdict instruction, page 31 of 34 state.
Okay. Okay.
Defense?
No objection.
Moving now to 32 of 34, instruction 3.13, submitting case to jury. The only other question I have for the parties is with regard to, I believe it was Exhibit A, the suitcase. Are we going to send that back, or is that going to be viewable upon writing similar to the baseball bat?
No reason that it can't be sent back.
Okay, agreed?
Agree.
Okay, all right. Is this instruction acceptable to the state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Very good. And then moving to, that concludes the, except for the 3.6F and 3.6G instruction, that includes the verdict or the instructions. I'll have Anita clean that up and send it to the parties so that we have a cleaner red line to work with. The only other question that I think we can address this morning is the verdict form. I received the defense's verdict form. It looks like manslaughter is no longer being sought in the verdict form. Manslaughter was struck out and it was just culpable negligence.
Under the defense's part, yes.
Right.
Yes.
Okay. So how do we want to address the verdict form then? Because if we're giving instructions on manslaughter, it certainly needs to be included in the verdict form.
I understand, Judge, but the defense isn't requesting manslaughter, but if it's instructed, it has to be in the verdict.
Okay. So the verdict form would read, we the jury find the defendant guilty of murder in the second degree as charged in the information. We the jury find the defendant guilty of the lesser included offense of manslaughter. We the jury find the defendant guilty of the lesser included offense of culpable negligence. We the jury find the defendant not guilty. Is that acceptable to the state?
Yes, Your Honor.
Is that acceptable to the defense?
Yes, Your
All right. Similarly, I'll have Ms. Barrios make those revisions and submit them to the parties as soon as possible. Anything else, state, we need to address before? Bruce, do we have everybody as of this time? Everybody's here? Thank you, sir. Other than the 3.6 instructions and the state's request for other instructions, which I think we'll have to table for now,
Yes, sir.
are we prepared to go ahead and bring in our jury at this time?
Only thing I wanted to bring to the court and the defendant's attention was apparently yesterday at lunch there was some sort of domestic violence event out in the quad. The coworker indicated that without believing it was any particular jurors in this case, that he did see people with juror badges in and out the area. So I don't know if that warrants inquiry by anybody.
Defense?
I think it should be mentioned.
I agree.
Okay.
I agree.
Just to see,
Sure.
we've spent all this time, we've got a bunch of alternates. Let's utilize them, but I do have an issue.
Yes. What do we got?
I think the state attorney, the last piece of evidence is they extracted from Sarah Boone's phone a bunch of pages of text messages. And I believe their intent is to introduce all those text messages, which are quite a few, but I think they want to read specifically out a few to the jury. My only concern is I don't know which ones they're going to read out, and under the rule of completeness, if there's a thread where it needs to be put in context, we would ask that all of that be read. So I don't know exactly what they're planning.
Mr. J, any response?
It's going back with them, just like I told them during some of the body-worn cameras. Only some of it's published. It's all going to be there for them to use. I do not intend on reading all 108 pages. I don't intend on trying to delineate what contextually is one conversation from the other. I think it's just fair to say this is all going back with you. You're going to have a scrub laptop. You're going to be able to view it all.
Okay. Mr. Owens, you can make any objections you deem necessary at the time, and we'll address it. Because it's just hard for me to say what should or should not be. I understand the state's position, but if it's something that's you believe in the rule of completeness should be provided at that time, regardless of it going back, we'll address it.
And it's going to be about 40 minutes worth of reading text messages. Are we going to have some people come in to read the messages?
Again, I'm not sure how long it's going to take. I do not practice reading what I'm going to be reading in the mirror. Number two, no, I don't understand why a witness would be called. It's in evidence. The lawyers can now publish them.
Okay. Anything further, Mr. Owens? Okay, all right.
Not on that issue, I would like to take like 5 minutes to use the bathroom.
Sure, we can do that. Okay, so I don't want to highlight that it was a domestic violence event. So are the parties, is it acceptable to the parties to inquire of if anyone heard or participated, got any information, or observed anything of the event that transpired yesterday afternoon in the courtyard? Is that acceptable?
Yeah, you definitely shouldn't suggest what it was.
Agreed. Okay, got a thumbs up from Mr. Owens. All right, we'll take a 10-minute recess. We'll just plan on bringing back here at 9:30. We'll bring the jury in at that time. Thank you all very much.
That turnaround area there previously?
The turnaround area in front of the barn?
Yeah.
Yeah, all that was there. Some of it was gravel. I believe the new owners have asphalt, the black asphalt. They've added that since, but the layout was the same.
Right.
This is S. Farris 11. Again, with depending where the burn pile is, kind of to the left of the burn pile, as you look at the photograph, was there a area downhill? It was very steep going downhill where the trail camera was.
Yes,
And a couple jurors could walk down there, but that was down that way along the fence line.
correct. And if I may, the trail camera was pointed towards the other property.
To that where that fence line went, right?
Correct.
You think anything else?
The other house, all the other houses, there hasn't been any new homes built in
Not that I
the
observed.
meantime. All right.
No.
Just that's all I have, unless the defense has anything.
All right, anything, Mr. Ray?
Just one thing.
Go ahead.
With the trail cam that Mr. Bogus has talked about, and we had talked about it before the jurors arrived, we don't know the exact location where the trail cam was found.
Correct. I never viewed the trail cam attached to the tree. I was just given the general location, so I didn't know exactly which tree it was attached to.
That was it.
All right. Anything else?
That's all this morning.
All right, you step down. We need a short break.
Do you want to? We're good.
Judge,
No,
what is that?
any other questions?
1 second.
All right. All right. I need y'all to step out. It'll be a short 5-minute break.
You all can be seated. Thank you. All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for counsel, starting with counsel for the state.
Dave Castro on behalf of the state. William J. for the state.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone is still seated at counsel's table. Are we ready to go ahead and bring in our jury at this time? State.
Yes, sir.
Defense.
Yes, sir.
All right, let's stand and bring in our jury.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, members of the jury, you can be seated. Members of the jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Just again, if you could raise those hands, confirm you complied with the court's instructions. All right, all hands have been raised. Thank you very much. Members of the jury, before the state continues with their evidence presentation today, I just have a couple of questions to go over with you. Yesterday, there was an event in the courtyard of the Orange County Courthouse. Did anyone happen to observe that event? If you did, please raise your hands at this time.
What do you mean by observe?
We'll get to it.
Okay.
Okay. Did anyone happen to hear anything during that event? All right. And record reflects no hands have been raised. Did anyone see anything during that event? All right. Juror number 2, first row. Thank you, ma'am. Did anyone participate in that event? Record reflect no hands have been raised. Did anyone receive any writings or review any material from that event? Record reflect no one has raised their hands. Can the parties approach for a moment? All right. Members of the jury, I'm going to send everyone out except for juror number 2 in the first row. We've got a couple follow-up questions for you individually, ma'am. Same instruction I've given you all previously. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved. And don't have any discussions amongst yourselves or anyone else, and we'll bring you back in as promptly as possible. Thank you. You all may be seated. Thank you. Juror in seat 2 on the first row from right to left. You had advised, based on the court's question, that you had observed something. You said, what does observed means? And instead of getting that out in front of every other juror, we just want to have that individual conversation with you now. So tell me what it is that you saw or heard or anything yesterday in the courtyard yesterday.
When we were walking back from lunch, and we saw that they were gathered, and I asked the deputy if he knew what was going on, and he said it was somebody Bain talking about domestic violence.
Okay. And you said we were walking. Who's we?
Another juror. I don't want to say her name.
Okay. All right. Is that a juror that was on our panel here?
Yes.
Okay. All right. Do you recall where they may have been seated?
No. In the back, over there.
Okay. All right. Do you recall what color her hair was?
Yes.
What,
You want me to tell you?
Please.
Dark brown or black?
Is it the shorter juror? Okay. Thank you very much. State, any further questions?
And after you were told what was going on, then what happened?
I walked back in.
All right. Did you hear any of the speakers?
I couldn't hear anything, no.
Anything further from the defense?
Ma'am, did that affect your ability to be fair and impartial? Thank you.
Can the parties approach for a moment? We appreciate you, ma'am. Thank you so much. We're going to go ahead and bring in the balance of the panel. You can just hang out where you're at, okay? We stand for you. You do not need to stand. We stand for you.
Jury entering.
State, you recognize our jury.
Yes, Your Honor.
Defense, do you recognize our jury? Yes. All right, you all can be seated. Thank you. Again, members of the jury, if I could see those hands, you complied with the instructions during that really short break. The record reflect all hands have been raised. Thank you very much. Mr. J, you may proceed, sir.
Permission to publish from States 21, which was previously marked as P for identification.
You may proceed, sir.
Again, this is a DVD exhibit with two folders in the main directory. One entry is in a folder called Attachments. Another is a PDF labeled Extraction. And for the record, it is 108 pages, and the entire document will go back to the jury, and there will be a laptop provided to them to utilize this exhibit. For purposes of publication, I'm going to go by page number and date unless something requires more specificity. And for to and from, I'm going to just use the name of the contact if one exists or the phone number if one doesn't. On page 1, creation time for notes, 7:49, asking Jorge or George not to be despicable to me, making more drink after he guzzled his and I shared mine. On page 2, date March 8th, 2018, you are now in a relationship with Jorge or George on Facebook. Metadata entry 100014, etc. for Jorge Torres to Sarah Boone, owner. Page 3, May 21st, 2019, from 407-716-8684 to Melissa. And he can still live here, correct? Or until I decide to finally get him out if he doesn't clean up his act after tomorrow. On page 9, May 30th, 2019, from a contact labeled as Mom, Jorge or George, to 407-716-8684, which I will just refer to as owner in future references. Where is my clippers in the gray box? From owner to Mom, Jorge, all capitals, dumpster, separate message, like you, separate message, so is your 2 shirts, separate message, no more Rick and Morty, a response from contact Mom Jorge to owner, okay, from owner to Mom Jorge, Lucas cried when he saw the adventure fund was gone, thank you, no wonder you're out, fuck off. From owner, he's the one that broke it because you took it. From owner, wanted to go on an adventure. On to page 10. From owner, be proud, feel good. You made my, quote unquote, our son cry. Cheese stick, Lucas, your kids, get the fuck out of my life and my son's. No one, spinster, good, for nothing, dumpster diver, that's what you are, and the rest of you. Later on this same page, owner to Mom Jorge, get all of you, mean, selfish, fuck all you, your firstborn is a joke. Going on to page 11, same date of May 30th, 2019, from owner to Mom Jorge, get the fuck out of my life. Lucas 2, bad influence. From Jorge to owner, I am, as you can see, go drink your life away. From owner to Mom Jorge, your kids are too. Yuck. Shucks, I only have 1. Beaters, your 3 together. Yuck. Going on to page 12, from owner to Mom Jorge, still dated 5/30/2019. Gross, and all the time, gross. Mom Jorge to owner, I love that guy. You're the one who kicked me out. Owner to Jorge, Mom, finally. Get your shot together and check me out in 2 to 3 months. Hope you're there. Unless I find someone better. Shit. Together. From Mom Jorge to owner, are you serious? Are you serious? Owner to Mom Jorge, that's what happens? No. Mom Jorge to owner, I'm helping out Dad right now. Call you in a few. Owner to Mom Jorge, can you help me put out, fuck off? Jorge, Mom to owner, how? No problem. From 267-216-5170 to owner, damn. You can only talk when you're drunk and talking shit.
Owner to the previously mentioned 267 number, stop calling, texting my phone. He's not here anymore. And it's damn 267 number to owner. NP, you didn't have to be a bitch about it. Owner to 267. Going on to page 13. Still May 30th, 2019. Yo, I like you all. He's a dick and the sheriff just left. Sorry I couldn't text back. I'll always respect you all. You know that. He's not here anymore. And yes, I am a bitch. So are you. 267 to owner. Look, I'm not here to be taking shots at you. I never called you a bitch. I said you were acting like one. I'm not going to be here going back and forth on some childish shit. Have a good night. Owner to the 267 number. Friends forever, thank you. Would love to chat sometime. Call his parents, I guess. Further down on page 13, now on to May 31st, 2019, from owner to mom Jorge. Tell Jorge to call me. I want my things he took. I have his birth certificate and propane certificate until then if he wants those back. And I have your quote-unquote art box. Mom Jorge to owner, stop being petty. I did not take anything that wasn't mine, I swear. Owner to mom Jorge, you're a liar. I never can believe you from all the other lies. You stop being petty and take shit like you always do. Another one bites the dust, Jorge. Hope you're miserable like you've made everyone else. Mom Jorge to owner, I'm not lying. Owner to mom Jorge, Lucas said he won't miss you either. When I get mine back, you'll get yours. Mom Jorge to owner, I didn't take it. I'm coming over in a few to get my stuff, and I'm coming with Jean and Melissa. Going on to page 14. Owner to mom Jorge, go for it. Bring mine W. Mom Jorge to owner, I don't have anything of yours, that's why I'm coming with them so they can vary that. Owner to mom Jorge, I don't care. They're not going to babysit you because you're an asshole and got kicked out after being taken off the lease. Mom Jorge to owner, they seen what I had in my hands. Owner to mom Jorge, still don't care or believe you. I'm going to get Lucas anyway, so don't waste their time or mine. Mom Jorge to owner, exactly. Owner to mom Jorge, you were a visitor and a terrible resident, boyfriend too. Just go away unless you bring my stuff. Mom Jorge to owner, I don't have your shit, Sarah. I need my birth certificate. Owner to mom Jorge, I don't give a shit either. I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on them doesn't make them yours. Even paid for them. I needed you to be a man and take care of me, not beat me, call me names, and make me feel like I'm not a person. Not giving back until I have mine. Mom Jorge to owner, whatever, Sarah. Owner to mom Jorge, next step is restraining order. Know that. You can come over here 100 times. Doesn't mean I have to open the door. Good one, Jorge. Go away. Mom Jorge to owner, whatever. Owner to mom Jorge, it's been a great day without you. Will be from now on. Mom Jorge to owner, you need to do. Owner to mom Jorge, enjoy living with your parents at 41 with no girlfriend and lonely. It was the inevitable, just like it has been before. Owner to Jorge, mom, did you take Lucas's sunglasses? Mom Jorge to owner, OMFG, no I did not. Turning to June 2nd, page 15, 1:10:57 a.m. from owner to mom Jorge. Jorge, question mark, call me. If Jorge is with you, can you have him call me, please? Text to Mo. 1:18, 16 seconds on June 2nd. Owner to Mom Jorge, I beat you to the punch. Want to do the dartboard with me? Come. Owner to Mo, I know you won't answer, Mo. Tell him to come finish the dartboard with me, please. Owner to Mo, I miss him. Owner to Mom Jorge, ask Jorge to call me, please, when he gets a minute. June 2nd, 7:43:40 a.m. Can you have Jorge call me, please, when he gets a chance if he's with you? 7:45 a.m. Owner to Mo. Going on to page 16, June 2nd, 2019, 10:50 a.m., 55 seconds. Owner to Mo. Hello. Can you please have Jorge call me? Willing to give back. Don't know if he's there or at parents. Really want to see him. Owner to Mom Jorge at 10:52, 16 a.m. Not pursuing after 12 o'clock. Ever again. (12:19 p.m., 23 seconds. Owner to Mom Jorge. Please call. Come over. I'll come get you. Come over, please. I need a super hug. Hugs? Please. Need. You. 6:23 p.m. Owner to Anna. He doesn't live here anymore. Call parents or Mo in response to an incoming phone call that was made at 6:10 p.m. 54 seconds from Anna to owner. Entries 9803, 9804 in the PDF timeline, June 2nd, 2019. Image 0092.heic, captured 6:33:01 p.m. Image 0093 HEIC, captured 6:33:26 p.m. Publishing from attachments. Image _0092, metadata showing 6/2/2019, 6:33 p.m. And image or IMG _0093, metadata, date taken 6/2/2019, 6:33 p.m. (6:34 p.m., 51 seconds, June 2nd, 2019. Outgoing from owner to Mom Jorge. All up to you now, big boy. And for the record, those images were sent to Mom Jorge at 6:34 p.m., 33 seconds. Look what you made me do. Or maybe your mom will for you. Response from Mom Jorge to owner. Wow, that's really childish. Owner to Mom Jorge, but effective. Mom Jorge to owner. Yeah, I see what you are doing. Did Lucas leave? Owner to Mom Jorge. I'm watching shadows. Be gone for good. Minus birth certificate. Mom Jorge to owner. Okay, cool. Enjoy. Owner to Mom Jorge. Am. Nice. You're not. And nice was from Mom Jorge to owner. Going on to page 17. This is still June 2nd, 2019. Mom Jorge to owner. Yes, I am. You are not, though. Owner to Mom Jorge. To who? Your mom? Brothers? Not me. Mom Jorge to owner. To everyone. Owner to Mom Jorge, but me. Mom Jorge to owner. I love you. Owner
to Mom Jorge, I'm going out at 8. Get dressed. I've given you since noon. Peace out, Boy Scout. Mom Jorge to owner, I'm coming over with a handle. I was helping Pop all day cut grass. Owner to Mom Jorge, yay you, getting in the shower then out. Bye-bye. Mom Jorge to owner.
Excuse me, can we approach the bench?
Yes. Objections overruled.
I'm already showered and dressed. Mom Jorge to owner. Hello? Text from Anna to owner. You're rude as hell, but okay. Owner to Anna. Your dad is a POS, but okay. At least you know and will stop calling. Owner to Anna. Futile. Anna to owner. CTFU as you are a piece of shit, but that's God's business, not mine. Have a good day, coke whore. Since you like to switch it up, I'll do the same. Don't text me back either, fake ass. Page 20 of 108, June 9th, 2019, from owner to Philip. He's off the lease. The process has begun. Page 22, June 11th, 2019. Metadata only shows to Mom Jorge. You tell your son he's not welcome here, taken off the lease and bound, worthless. Don't show his ugly fucked up face around here again. Police will be called. Ask him if it was worth it and ride my bike he has. Stay Hispanic, that's what you all are. And he can watch all the porn he wants from the phone Mom gave him. Page 26, June 14th, 2019, 11:38:56 p.m. To Mom Jorge. Wow, congrats, blackouts and whoring. We wanted to see him. Hot house, 7 people. Mission to work on my bike. Repeat. Candy Crush. Fuck himself. Shit job. Repeat. Same page, June 15th, 2019, 7:37 p.m., 48 seconds. To Melissa, just an FYI, if my place gets effed up, I'm letting you know. He's in jail. Thanks for the prompts. I'm at my ex's house. Please don't let this reflect on me as a tenant. You said to call cops. I did. He's gone. We're both proud now. I consider you my friend. Melissa, why was he in your apartment?
Page 38, notes, creation time, June 26, 2019, 5:56:57 a.m. 6:14, videos, 10:03 a.m. Sarah Banks, 5:3 Bank, 6:13, Metro Activation 6:12, skipping down, X videos, 6:2, 6:13 p.m., X videos 6:1, X videos 5:31, 9:56 a. Who's Christine? Paren FB. Going to meet up? Question. Calling her beautiful? Question. Said she thought you were avoiding her when down here. Said no, I was not beautiful. FB-nonchalant Quay. Thanks for adding me. You are exquisite. Facebook messaging Camille 6:13, 9:42. Facebook or FB Pamela Erickson sending pictures of yourself, telling her good morning 7:14, 12:13 a.m. FB-Crystal going to woo her, sweep her off her feet, going to change her mind. Luck is my middle name. Sent her pics, kiss emojis, called her beautiful after returning to the convo. Said you had to pick up your brother, sent pics of beer. Sent her struts, could have been me. Sent her songs, but not me. Messaged bunny kiss emojis, convo. Sent puppy kiss emoji. Would love to take her out and see a movie. Told her about what we do in the shadows. Would love to watch Creed 2 with her. Want to snuggle with her and eat popcorn. Sent heart-hugging animal emoji. Want to play a board game with her. Asked to FaceTime call her. Called her amazing. Messaging at 7:30 a, 6:14, 6:15, 2 days. FB-Crystal liking all her posts. Quote, losing someone who doesn't respect or appreciate you is actually a gain, not a loss. Can't compare me to the next girl because there is no competition. I'm one of a kind and that's real. Continuing on to page 39, same note. I found everything on your phone, all your messenger texts, telling Christine you want to meet up with her when she's here, calling her beautiful, thanking nonchalant Quay for adding you and calling her exquisite, telling Pamela Erickson good morning and sending pictures at 12:38 a.m., messaging Camille, then the whole 2-day convo with Crystal, how dare you, and send pictures wearing my wedding ring. You're a cheating, lying scumbag. I will never trust you. Why don't you put your mugshot up, or I will, since I have your phone, and log in and tell everyone why you were in jail for the 3rd time. Let them know you beat your wife and she put you there because she couldn't take it anymore. I want nothing to do with you ever again. I've become a different person since you've been gone, with less stress, anxiety, and worry. I feel safe, comfortable, happier with you not here or seeing you at all. I can say through I do have heartbreak after going through your phone. Thank you for always proving me right. I knew when you told me your mom gave you one that you'd be back to your slimy ways. You will never change. I hope it was all worth it, all of it, including losing my debit card for the 3rd time to buy beer and cigarettes, which put you back where you belong. I know for a fact you were not worth any of it. I just can't believe after everything I've done for you, including all I did to get you out of jail, and you do this to me. This is cheating. Goes on to page 40, goes on to page 41, and ends with never truly yours. Page 42, June 26th, 2019, 8:06 p.m., 16 seconds. Outgoing from owner to Mo. Just wanted to let you know to tell Jorge I found all his messages, kissy face heart emojis with Crystal and other bitches on FB, along with all his porn after he swore to me he wasn't doing any of that anymore. I'm not doing anything more for him, and he will try and keep him in jail as long as I can. Cheating snake weasel. Ask him all about it or have your parents the next time they talk to him. I'm not anymore. So hurtful after all I've done for him. He can rot in there for all I care. Going on to page 43, to Mo from owner, and I will be there for the hearing next week and his arraignment on both charges. Peace out, fucks, aka Torres. Same page 43, from owner to Mo, 6/26/2019, 9:59:14 p.m. Begins, hi, I was thinking if you could get out, I'd really love it if you'd take me to a movie, or we could snuggle like we do and watch Creed 2, get some popcorn and pretzels, maybe talk about what kind of other movies we like, or find a fun board game to play together. I know your favorite is Avalon. What do you think? I was also thinking the other day about how much I miss you sending me pictures of yourself throughout the day, sending me songs you wanted to hear or thought I'd like, but what I really miss are the kissy love emojis you would send, just because I really miss those, especially the ones with hearts. They'd always make me smile. I knew you were thinking about me. You do Crystal, though. Even asked her to FaceTime. What would you do if you found me having this convo with Ben or John or anyone other than you? I'd be beaten to a bloody pulp. And don't do any of these things anymore, but yet you wear your wedding ring and mine around your neck and tell me how much you love me. But you're telling this woman who looks like TPT you want to snuggle with, take out to a movie, play board games with, questions, sending music, cutesy, kissy love emojis to like you used to me, telling her you want to woo her, sweep her off her feet. How do you think that makes me feel? Why don't you say that to me? Going on through the rest of page 43, page 44, including on page 44, dirty cheat, enjoy your porn and jerking yourself off secretly so your parents don't see you and your ugly new girlfriends. I can't wait to finally be with a real man, Ben, who will and has taken care of me. Can't wait to see what he's like in bed. I already know he kisses. Hope it was all worth it. I'm free. As you told Crystal in your messenger text, you're single with a little cutesy dancing dinosaur. Wow, now you really are. You're despicable. Next text is XOXO, from Mo to owner. Page 50, 6/28/2019, 10:55:47 p.m. from owner to Mo. Just know I can do so much more damage than all of you put together. Know that. Going on to page 51. Try me. Page 72, July 20th, 2019, 11:34 p.m. From Janice to owner. No metadata, but from Janice. Sorry it's so late. I just read your text. He seemed fine when I saw him at your apartment this morning. He answered the door right away, but was quite bummed out. He overslept, but I was okay and told him, no problem, just get ready and come to work in about half an hour.
Then I texted your phone and asked if he would rather work the afternoon shift and get some sleep, but he never answered, so I have no idea where he is or what he's doing. What happened last night, he had a black eye. He said it was new because I asked him and I told him to put makeup on it. He said he had that taken care of. Did you two get in it again? He acted like when I told him he had a black guy, at first he didn't know what I was talking about. I guess he kind of blacked out. You can call me back if you want. (11:30 p.m. 38 seconds). From owner to mom, Jorge. Janice just called me looking for Jorge and she's pissed. Congrats. Page 82, 8/21, August 21st, 2019. From Jorge to owner. I love you, my friend, my love, my queen, my everything. Your Honor, that concludes everything I'm going to publish to the jury on this exhibit.
Okay.
Judge, will we approach you then?
Yes. right, members of the jury, thank you for your patience. I just have a short instruction to read to you. Members of the jury, the state showed you portions of what was entered into as State's Exhibit 21. It is not the entirety of State's Exhibit 21. The entirety of State's Exhibit 1 will go back to you into the deliberation room with a laptop for you to review all the exhibits and text messages and the total conversations over and above what was highlighted by the state. With that, State, do you have any other witnesses, evidence, or testimony to provide?
Your Honor, at this time, the state rests its rebuttal case.
Okay. Anything further from the defense? You want to approach?
I just think we have some issues outside the presence of the jury that we need to address.
Okay.
I have one thought that requires a quick approach.
Come on up. All right, members of the jury, we're going to go ahead and excuse you for a couple minutes. I got some things I have to discuss with counsel outside of your presence. We'll bring you back in for additional instructions on where we think we're going to go after that. Similar instruction that I've given you over the last couple of days. Please do not conduct any independent research or investigation with regards to the persons, places, things, or charge involved in this case. And do not have any discussions amongst yourselves or anyone else about them. We'll bring you back in as promptly as possible. Thank you. Y'all can be seated. Thank you. The state has rested. Mr. Owens, do you have any intention on putting on a sir rebuttal in this case, sir?
I can have one more.
Yes, sir.
Judge, we did not intend to put on a sir rebuttal for the defense.
Okay, thank you. All right, Ms. Boone, I've got a couple of questions to go over with you, ma'am. You were previously sworn this morning. You've had the opportunity to review and participate in the trial. You've had the opportunity to review the rebuttal case as provided by the state. You've had the opportunity to review and listen to that evidence and witness any cross-examinations as it relates to the state's witnesses in their rebuttal case. Are you satisfied with your attorney's representation of you in this matter?
Definitely.
And are you still on board with the strategy that has been utilized in your defense?
Yes.
Now, your lawyers yesterday told the court that they may want to put on a surrebuttal, which would be a limited rebuttal to the evidence presented by the state in their rebuttal, both yesterday and today. Your lawyers have indicated that they do not intend on doing that. Similar to other conversations we've had, ma'am, I don't want to know specifics. I just want to know if you and your lawyers have had these conversations. Have you had a conversation with your attorneys about putting on a surrebuttal or a reply in response to the state's rebuttal?
Yes.
You had that conversation?
Yes.
Are you on board with the strategy employed by your lawyers that they are not seeking to put on a surrebuttal in this case?
I am.
Okay. All right. Is there anything else that we need to address, state?
No, sir.
Judge, you remember you were going to speak?
Yes. Thank you, sir. Ms. Boone, at the conclusion of the state's presentation of State's Exhibit 21, Mr. Owens had approached and had advised the court of some objections, specifically with regard to the co-ownership or co-usage of the phone. The court is not permitted to comment on the evidence, and your lawyer was seeking an instruction from the court to advise our jury that both you and Mr. Torres had access to that cell phone. I am prohibited from commenting on the evidence. Now, that doesn't prevent your lawyer or the state from speaking about that in their closing arguments. Just as a matter of law, I am not able to advise the jury as to what that evidence is. The second request pertained to the state moving from place to place through those 108 pages, moving from timestamp to timestamp. The state chose to present that evidence in that manner, which is why I gave that instruction to the jury that not the entirety of Exhibit 21 was provided to them as to what the state produced, and they'll have to have the opportunity to review that in its entirety when they go to deliberate. Do you have any questions about that so far?
So far, no.
Okay. The last portion, ma'am, pertained to the cadence or tone in which you and Mr. Torres communicated with each other. I have no knowledge as to how you and Mr. Torres communicated in text form as to what the tone was behind those words. Your lawyer advised me that there was an objection and you had some concerns as to the way Mr. J may have read those text messages to the jury. I found that the way that he read them was benign, in a flat tone, and did not exacerbate or excite any of the language that was in there. He had read them in as a monotone way as possible in presenting to the jury, and I didn't notice any changes in his cadence or heightening or lowering in the volume or tense or tone utilized in presenting that information to the jury. Do you have any other questions for me, ma'am?
No.
Anything else we need to address, Mr. Owens?
No, sir.
Anything else we need to address, state?
No, sir.
Okay. How would we like to proceed with the charging conference? Do we want to bring back on our jury? It is 10:33 and advise them this is when we think you want to come back because we're going to be addressing the law to provide to you, and that's something I need to do outside of your presence. How do we want to proceed at this time?
I think, hopefully, at 10:33 to about noon should do it for 3.6F. It is convoluted, but I think the parties have narrowed it down to really just a couple of things.
Okay.
So I would suggest saying something along the lines of, we have to finish up getting the jury instructions ready for you. That's something that we have to do now after the evidence is concluded, and we'll see at 1.
I say 1:30, Judge, in the abundance of caution, because Mr. Henderson, I know this is going to be an issue, and it's going to take a little bit of time, and then we want to go to lunch and give them a chance, because there's going to be a 3-hour speech session. I don't know if you give them a break in between the prosecutor's statement and my statement, or how you do that.
We may, depending on just the time of it.
But from 1:30, that's going to go to 2:30, 3:30, 4:30. So just before 5, I think that's plenty of time in case he goes a little bit longer or I go a little bit longer.
And I still have to read the jury instructions as well. So, I mean, with 34 pages, and I read quickly, as Madam Court Reporter will advise me.
Are they going to have
Yes.
reading along with you?
Yes, so once we make all these changes, every member in the box will have a paper copy. You, Mr. Owens, and your team, along with Ms. Boone, will have a copy. The state will have a copy. Madam Court Reporter will have a copy, and I will. And I will read line by line all the way up into the 2.7 instruction. At that point in time, I will stop. I will advise our jury that we're going to begin with closings. State will go, you will go, state will have an opportunity for rebuttal, and then I'll finish with the verdict and final instructions. Discharge our alternates at that time. I'll go back and thank them and give them their jury certificate forms, and then we'll release the jury. I'll have a final colloquy with your client, and then we'll review all the evidence to send back with the exception of the baseball bat.
And perhaps in case they haven't inferred, let them know that they're getting the case tonight, so make plans to stay later.
Yes.
How late are you going to keep them?
9 o'clock is the norm. I may, because it's the weekend and it's Friday, I may seek special dispensation from the chief to stay longer. I plan on communicating with the chief during the lunch hour as to that issue,
I think that would be great.
if she'll let me. I don't know if it's at her discretion. I know I have to seek approval after 7. I'm not worried about that. I know, and I would prefer them to work late into the evening if they're on board with doing that, rather than coming back Monday. Okay, all right. If you all would be so kind to give me a moment so I can go back up to chambers, get with Ms. Barrios, and I'll give paper copies of everything from the revisions that we made this morning. Let's go ahead and bring back in our jury. And I agree with Mr. Owens. I'd rather us waiting on them than them waiting on us. So I think 1:30 is the way to fly. Let's go ahead and bring back in our jury. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, I do.
All right, thank you. Y'all can be seated. Members of the jury number 2 in the back, he's ready. He gets it. All right, can you raise those hands one more time for me? All right, record reflect, hands have been raised as compliance with regard to the court's instructions. Members of the jury, all the evidence and testimony sought to be provided by the state and the defense have been provided to us over the last week. At this point in time, the state and the defense and I need to discuss the law to be given to you in instructions. That's going to take a little bit of time. So we're going to go ahead and excuse you at this point in time for a longer lunch break than what you've had previously. And we're going to ask you to come back here at 1:30. At that point in time, the court will begin to instruct you on the law that you are to apply in this case. Then the parties will begin with their closing arguments. The state will go first, then the defense. Then the state will have the opportunity to rebut any of the defense's arguments. After hearing the closing arguments, the court will provide you final instructions before releasing you to deliberate in this matter. We may work past 9 o'clock tonight. We may go late into the evening. So if there are any plans or things that you need to reach out to, as we discussed last week during jury selection, that we could work till late as 9, and we may work later than that this evening. If there's anyone that has any concerns as to working that late, please raise your hands at this time. Court sees no hands. I would also ask of you, if you could, please reach out to any family members or friends to, one, advise them that you're on the jury and will be deliberating this evening. And if there's any accommodations or issues with minor children or family that need to be taken care of, I would ask you that you take care of that during our lunch break.
And the emergency phone number, since they won't have phones.
Yes, we will provide you The court deputy will provide you the emergency phone number when we get back from lunch so that you can provide that during a break that we'll have this afternoon to any friends or family or loved ones if they need to get in contact with you. I will give you a similar instruction that I've given you over the last couple of days. I know you're probably tired of it, but I got to give it to you one more time. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not you must not use phones, computers, or electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your attentiveness, service, and sacrifice, and we'll see you at 1:30. Juror number 2 in the back. Yes, sir.
Question. So
Answer.
with the parking, we're going to be here for some time. Can we leave and come back and get re-stamped with a new thing?
We will have you that answer when we come back.
Okay.
Madam Clerk's going to figure that out for you.
Okay.
All right, thank you very much. Yeah.
Get. Okay. Ask.
No. Okay. Could you do that, Officer Jones? So I've been advised by, you know what, rather than double speak, could you just tell me what it was, say it for the record what it was?
If judges approve that they are to go off campus or out of the courthouse garage, they can come back and get new stamp cards.
So they can leave this point during lunchtime.
And I'll approve that. So, State, anything else we got to discuss other than the jury instructions? Defense?
No, you.
Okay, court's going to run upstairs, put the finishing touches on what we agreed to this morning. I'll bring back paper copies for everyone, and then we can continue the charging conference at that time. Court's going to be in a short recess. We'll be back as promptly as possible. Thank you.
Thank you, Judge.
Formula manufacturers after her premature baby was diagnosed with necrotizing enterocolitis or NEC after receiving bovine-based formula. The lawsuits allege that Enfamil and Similac premature formulas, they are linked to NEC, but manufacturers, they failed to warn the public of the risks and targeted them with false advertising. So if your premature baby was diagnosed with NEC after they were fed Enfamil or Similac, you may qualify for compensation. And one of our legal partners is partnering with Wagstaff Law Firm, a national firm renowned for their expertise to ensure that eligible claims are thoroughly presented. Just visit babyformuladamages.com/YTT.
Oh, sure, absolutely. May I approach you?
Thank you.
You told us that at the beginning of the trial, but habit.
So this is July 3rd, 8/28, which is 2028. So the 8/28 point there is indeed a Wi-Fi source.
That's a Wi-Fi source.
Correct.
Okay.
Based upon the record.
Well, so what about 8:30? Could that possibly be? I mean, up through 8:40, I don't imagine you could still be on the Wi-Fi that far away. That's a number of miles, is it not?
Well, so exactly. So your records here, again, being the geofence,
Sure.
at 8:30, that moved outside of the geofence, so it's not on this record.
So then your GPS, or what are you using?
Well, the record states it's using Wi-Fi.
Okay. But there are some GPS coordinates in that record.
Absolutely.
Okay. I'm asking you for this jury.
Sure.
When you created this, because you created this image out of data somewhere.
Correct.
So it's both Wi-Fi and then it's also GPS, or
It's completely based on what the record is.
Okay.
But I can't confirm what 8:30 is with this.
Okay.
I would need the Google return raw record to show you the source of 8:30.
Okay. All right, but not for this. This is the wrong record for that.
This is the raw record for the geofence. So
Okay.
once those points go outside of the virtual fence, that record does not show them.
Okay. So you got coordinates by time, and this is what came back. In this Gmail location between 8:30 p.m. and 8:40 p.m. on the 3rd.
So yes, these are depictions of certain data points during this time frame.
Longitude, latitude.
Longitude, latitude, and a certainty marker.
Okay. Similar to this document, but not this document, is what you did it with.
Correct. Those only are in the area of the fence.
Of
again.
the fence around the house.
Correct.
Okay. So we're outside the fence.
Absolutely.
Yeah. There we go. This one right here.
Yes.
So between 8:40 and 9:21, Gary Farris's phone did not move from this location.
That is correct. That is a precision location during that time, between that 8:40 to 9:21.
Now I noticed, for your other PowerPoints, you did like meters and how within the precision. I don't
Correct.
see it on this one.
Yeah. Absolutely. I should have indicated the meters there, but if you have the raw record, I can tell you the meters.
I don't know where the raw
Okay.
record is. But this is similar style that you used in the other images that we saw around the house and the burn pile.
That's correct.
Okay. But where is this?
So this is in the area of Freehome. I looked up this shopping center in that corner. Now it's called B&B Tavern.
Okay.
I believe back in 2018 it was a different restaurant.
So we've been Publix. That there's like a Publix in there.
Yeah, I'm really not familiar with that area.
And then literally across the street is the Freehome precinct that we've been talking about in this case, where Detective Hayes did most of the investigation.
I did not look at the relative. Again, I just looked at the phone's location.
Did you look up what this place used to be back in 2018?
I think I did.
Okay.
I don't want to misspeak, but it was a different restaurant.
All right.
I believe.
Could it have been Catch 22?
I believe so.
Catch 22. All right, so we've now seen somewhere in one of the text messages, which I know you've not been in here for this entire trial, but you have been through a lot of text messages. And I believe in this report it mentioned earlier in the day that maybe Scott and Melody were going to go to Catch 22.
Yes, around lunch, I believe.
All right. So this is where Catch 22 was in 2018.
I believe that is correct.
Okay. So did you ever review, did you know Gary was there? Did you ever extract any photo information from security cameras or extract any data about his credit card use or anything like that for Catch 22?
I did not.
Okay. Meaning there was a possibility that he could have had dinner with somebody and we have no idea who that was.
I can only speak to the location of the device during that time, based upon my analysis.
Device at restaurant. Okay. And so we think he left the restaurant about 9:26.
And it looks to be still in the area of the restaurant at that time, but the next data point is 9:32, and it is away.
Okay, so sometime between 9:26 and 9:32, we can reasonably extrapolate that he left Catch 22 restaurant.
Again, the device.
The device left. Okay. All right, then you have Gary's Gmail location back at the house with, this is a law, you didn't write it down because you wrote it on other ones, but how many meters of certainty is this?
I would have to look back at the raw record, but, you know, it's within
Did
that.
you bring your raw record?
I have a copy.
Could you look?
Sure.
Thanks.
So this is 9:34 on July 3rd. So this is a 29-meter certainty.
Okay. How many feet is in a meter?
I think it's around 3.3.
3.3. So then how many feet would this be?
29 times 3.3. Thank you.
And I'm sorry that we're having to do this, but at the end of the day, this trial is in Cherokee County, Georgia, and we're not on the metric system here. So I'm just trying to maybe
Sure.
help explain to the
Trust
jury.
me, the records in the formats they come.
Sure, absolutely.
95.7 feet, approximately.
So from the center of that circle, 95.7 feet, so almost 100 feet. That's what that is from the center of that circle.
Correct.
In every direction.
Correct.
Okay. So that phone could be anywhere in the middle of that circle.
Absolutely.
All right. So let's talk about this. So why do these certainty levels, you know, they bubble up and then they get small. They bubble up and then they get small. Can you explain that to me?
I cannot speak to the technology of Google. And again,
And that's fine. I was wondering if you knew the answer to that or not.
I can, that would be a Google engineer question.
Okay. So then we move off, and I think, you know, Miss Frankish did a great job of kind of drawing the pies coming off of the cell phone tower, and that's older science. That's been around for quite a while. Yes.
Yes.
Okay. All right. So then we move forward in time to 5:52 a.m. Gary's phone geofence location.
Correct.
All right. So I wanted to. You didn't simultaneously do any dots. That's what I call them, dots. But you didn't do any of your circles for the Wi-Fi at that time. Is there any reason for that?
Where are we speaking? Are you talking
You
about
know,
5:52?
After Gary got back from the restaurant, which none of us knew anything about until pretty much yesterday, could you... Okay, I'm just going to show you.
Sure.
What I came up with. I followed your instructions. And we've made our own maps based on your instructions of the latitude and the longitude and then the map display radius zone.
Sure.
So I'm going to show you what is marked as Defense Exhibit Harris 1. All right, so this is the same time period with latitude and longitude, which is marked within, I believe you said phase 3.
Of the geofence.
Of the geofence. So we're back in the geofence.
Okay.
And there's different measures, of course, Wi-Fi and GPS, and then there's another measure within the geofence.
Cell network.
So, and I don't think we had any of that for Gary, yes? Or no? And I can give it back to you so you can explain it to me.
If you're talking about in the geofence, but I do have them in the Google return.
Right, but in the geo.
Sure, I'll take a look. Thank you. I do not see any source of cell.
Okay, no source of cell. So these Wi-Fi pings, could you go look at the time period for 12:49 a.m. and 1:09 a.m. and 2 a.m. and 2:12 a.m. on 7/4/2018? So you could tell me how big the radius is on that.
So, am I doing 1249 through 109?
I believe that's the data point. Just that general area, so you could tell me how big that radius is in my picture.
1249, the radius is 28 meters. 109, 28 meters. 2 o'clock a.m., 28 meters. 2 o'clock again, 28 meters. 2:12, 28 meters.
Okay. So next I'm going to show you Harris 2. Defense 2. This would be 1:21 and 31 seconds in the morning on the morning of the 4th. Where does it show Gary's phone?
120.
And I want you to and make sure, check my work. The longitude and latitude dot and the radius that it says.
1:21 a.m. on 7/4. I don't show a record here.
All right, how about I approached with one where we've specifically got Wi-Fi pings? How about 123, 7/4?
So this goes 109 to 2
Okay.
2 a.m.
All right. Okay. Well, then don't check my work. But in this image, this is a very broad circle. Yes.
Relatively.
Okay. And so Wi-Fi. Tell me how Wi-Fi works versus GPS.
Again, I cannot speak to the engineering on how it's calculated. My common knowledge would be distance to the router, but I understand things can interfere with that as well. So I really can't speak to how it's calculated.
Okay, so you just don't know.
No, sir. I just analyzed the records that are given to me.
All right, but this geo coordinate is somewhere out, and it would include in this picture the barn and the pasture out near the road. Is that true?
That's what it appears, yes.
Okay. So my question kind of goes back to you as to why you would not use any of the Wi-Fi coordinates, because then they can get really large here.
Sure. I did use some Wi-Fi. We showed that in the restaurant.
That one.
Yeah, and to me, it didn't, the source doesn't matter. I mapped all locations. Now, for the simplicity of the presentation, to not make the map very convoluted, so this large section that you're showing here, this large circle, that would have all been purple. But within that purple area are all the little points.
All the little points.
Correct. During the same time frame, right? So within that large area are the little areas as well. So,
but what I'm saying is there's different means. You're trying to use Google in a way, and you're not an expert in Google. You're trying to use Google to pinpoint where a phone was and a time it was, but you're kind of saying, don't worry about this Wi-Fi stuff. Don't worry about the cell phone stuff. We're going to focus on this one because I like this one the best. I think it's the best.
That's actually not accurate. I mapped all of it, and what you saw in the presentation was the precision location that gives us a better idea of the actual trail. Like a cell tower, we know those are large, much larger areas. We can't get certainty.
Mm-hmm.
But when you have, within the same time frames, when you have smaller certainty within that large area, it's more precise.
Okay, so I checked your work too. I tried.
Okay.
And so here we are. Your dots, your dots, your dots. Back to a bigger circle. No explanation as to why. We did the same kind of thing you did, following the radiuses there. And then you got him back out here somewhere. The phone is in the woods on the other side. The jury's been there now, so they've seen this property. This looks like it's almost on the property next door because there's a driveway down through here. What's your explanation for that?
Of where the location of the phone
Yes.
is?
And then that's where the phone just kind of, I guess the battery dies.
So I will say on this map that you created,
Well, I can go back to your image.
Okay. We can show them the same because Google Earth does show a little bit different.
I'll go back to your image if I can figure out how to get there. There we go. Here we go.
Right.
This one right here?
Right, correct.
Okay.
So this is a much greater bird's eye view from the image you just showed me. As you can see, it does still touch part of the house, or could be, or a driveway. It's
Well, the
not
jury's
merely
been there now, and have you been out at the property?
I have
by the way?
not.
Okay. So this is out kind of in the driveway, in the woods. Chicken coop appears to be right there. But it's not in the house. Right?
I cannot say what that little sliver that it is touching is.
Do you have any clue where Gary's phone was found in this case?
I do not.
Okay. So, I mean, you went through, and by the way, I want to talk about all these phone calls. Your data.
Mm-hmm.
How do I make this full screen again? I'm sorry.
Slideshow from current site. From current site.
Where?
Yep.
Right here?
Mm-hmm.
Oh, right. I'm learning.
But now you gotta go.
Okay.
One you want.
So all your data extraction. Here's what I want to know. They talked on the phone a lot. Yes?
Yes.
I mean, you do a lot of phone extractions. Yes?
Yes.
Or you used to, at least back in
The
2018.
physical extraction?
Yes. Not now, but
Not
back
anymore.
before you were a commander.
Previously, yes.
Sure. Back then in 2018.
I did not extract devices.
Okay. But you've done a lot of this work, right? Because I believe
Analysis.
you've been qualified as an expert.
Absolutely, in analysis, I have done a lot of this work.
All right. So this is a lot of phone calls, yes? Between two individuals over a 6-month period? 3,478 phone calls, yes?
That is the total.
Like, more than the average person would call somebody, yes?
I don't know what the average person calls in text. I mean, this is total communication too. So
I mean, how many phone calls a day does that average out over 6 months? You got a calculator, you can do it.
Can you tell me how many days are in 6 months?
What's that?
How many days are in 6 months?
Oh, I don't know. 365 divided by 2, I guess.
What, these months?
I don't know. I'm not a scientist, so I'm never in exacts.
Okay.
That's why I became a lawyer.
Okay, we're going to say there's 82.5 days.
Okay.
And you want to know how many calls that comes out to?
Yeah.
Over 42 calls a day, or contacts a day.
You say contacts.
Could
So that's
be.
text messages. Okay. So that's not just phone calls.
Correct.
Okay. Contacts. That's 42 contacts a day. That's a lot of contacts, yes?
Depends what your definition is of
Okay.
call. I mean,
I'll let the jury decide that
Okay.
one. But they had a lot of contact. They still had contacts between 11 and 3 a.m. 18 of those in just this period.
Correct.
You didn't go back into 2014 when they met,
I don't have records.
or when
for
they
that.
started dating.
I didn't have records for that
Okay.
time.
Did you look?
For records?
Yeah.
I used the records that were given to me.
Okay. Did you go back into 2017? Could you have? I mean, it looks like you did for some of this stuff.
The records that were given to me, I believe, went back to July of 2017.
Right, but you only did 6 months. You didn't do the full year. Why?
I felt 6 months was a far enough range of data.
Okay. All right. Melody and Rusty communication by hour of day, 6 month time span. You know, got to get these. What are the number of reg? You got 295, 240. What do these numbers mean?
That's the number of contacts.
On average for that time of day.
That's the exact number of contacts at those specific times.
When you take all the contacts across 6 months, right?
Correct.
Okay. So, how did you add all this up? Did you do it with a calculator? What did you do?
So again, we use Penlink, the software, and ingest the records in, and in there I'm able to use statistical reports to say, you know, I'm interested in breakdown by day a week, by hour of day. So it helps me with this type of analysis for large amounts of data.
Again, you do not work for Penlink, correct?
I do not.
And you have not been. You're not an expert in Penlink.
I am not an expert in Penlink.
It's just a software. You hit download and it spits out this report. Yes?
I created the report within the software. It doesn't just spit it out for me. I have to give it parameters. I have to give it date ranges. I have to choose my phone number.
Right, but you put it in and it made this report, not you.
The software.
The software.
Absolutely.
That's what the software.
It reads the records and produces these numbers.
Right. You didn't sit here and you didn't draw this out. It did. The software.
Right. The software.
Okay. So let me get this correct. You did not do a geofence on Scott's phone?
A geofence was for the specified area in the geographic region, and 3 devices returned within that geofence.
Okay. So by no fault of your own, there was no geofence data on Scott?
Correct. He did not return within the virtual fence.
Right.
His telephone.
Because you're talking about a Google geofence,
That's
right?
correct.
So could it be that his phone wasn't a Google phone?
That is correct. He had an iPhone.
Right. So then it wouldn't be within that fence, right?
I mean, there's Google applications that could still be running on an Apple phone, but there was no return for the specified date and time within that geographic location that returned Scott's device.
But y'all could have gone out and looked for stuff like that for his device. There's different geofences used by different companies.
Yes, sir. And we didn't need to do a geofence because we knew his phone number, so records were obtained for his device.
But you don't have that very tight location like you do for Gary's phone. Wouldn't that have been helpful?
That really would be helpful.
Okay. And or Melody's phone. You don't have that kind of information.
Just cell site location. And that, again, based upon factors of the device, of location services, and we were able to get cell tower information on one of the devices.
Okay. But you had these phones, you did dumps, you were looking into them, and you could have said, all right, well, this phone uses Yahoo Maps a lot. You could probably have gotten from Yahoo a geofence, yes?
You know, I don't know what companies do geofences. Google is the most common that is used.
Okay. But it's a step that you could have taken. You could have gone another step further and looked into these apps to get more information on the phone of Scott Farris and Melody Farris and where they were. Yes?
Well, my role in this is, again, when records are obtained, I analyze them. So I'm not the one out there creating the search warrants and fetching the data. I analyze the records that are maintained or obtained.
Okay, so those records were never given to you, yes?
Correct.
Correct. But it would have been possible with those phones and those applications that more data could have been gathered to give to you to analyze, yes?
So specifically, like you said, Yahoo, I'm not familiar of a geofence of any other company.
I'm just using that as an example.
Okay. I am only familiar with Google geofences.
Like DoorDash. I like DoorDash, right? So DoorDash probably has a geofence at this point, I imagine. You could use something like that.
I am unfamiliar with any DoorDash geofence.
Okay. Are you aware that in 2023, Google discontinued this service? Are you aware of that?
I do know there was talks about them encrypting their data.
Okay, and making it so that you had to get it from the phone and not from them. Yes?
I did. I read articles about that.
All right, so now you can't do it this way anymore in the year 2024 the way you did it back in 2018.
I don't know if it is officially gone yet, but I did hear that Google will be encrypting their data based upon the size of storage they were paying.
Okay. I want to talk briefly about the activity. Going back to 9/7, 9:30, this was when Melody was at the Hedonism Resort.
That's when the device connected to Wi-Fi in the name of hedonism.
Okay. And then on 9:30, she was in Nashville, Tennessee.
Based upon the sequence of events in the device, it appears she traveled to Nashville.
I believe you mentioned something about a baby shower.
Yes, it appeared the following day was a baby shower.
Right. Emily was having a baby around that time. They were in town for a baby shower, I guess, right?
It appears so.
Okay. And then 7/3, obviously the date of this case, right?
The date of interest, yes.
Date of interest, yes. All right, so you're telling me that there's more activity at the Hedonism Resort and then at a baby shower event than when y'all are alleging that she somehow killed Gary and drug his body to a burn pile
I had sent everybody the state's legal copy as well.
Okay, very good. All right. Let me pull up the digital copy that I have. Give me a moment.
Yes, sir.
Okay. All right, the court has the 3.6F instruction as provided by the defense. As to the first paragraph, it is a defense to the crime, bracket S, bracket of second-degree murder and negligence if the actions of Sarah Boone constituted the justifiable use of or threatened use of deadly force. What say the state as to this instruction? And should not manslaughter be included?
It should be second-degree murder, manslaughter, and culpable negligence, even though culpable negligence doesn't involve an intentional act, but I'm not going to fight with it.
Okay. Any objection to that addition?
No, Your Honor.
Okay.
Judge?
Yes, sir.
Can I interrupt for just a minute? Because there's a special instruction that the state is requesting on causation.
Yes.
And that goes, it's going to come before the self-defense.
When it was used in the previous case that I cited, that I used it in 12 years ago, it's part of the instructions of second-degree murder. Yes, is where I would be requesting it.
And this is just so that we're all on the same page. Forgive me. This is the state's request for special jury instruction on causation.
Yes, sir. I suggest we table that for now and just get into self-defense.
Okay, all right. So we'll revisit the state's request at that point in time. So is the second or the first full paragraph is read, is that acceptable to the defense?
Yes, Your Honor.
Okay. Moving now to the deadly force definition that seems to track the language of the proposed jury instruction completely. Any revisions to that state?
No, sir.
Defense. It's your instruction, so I'm assuming you've got no quarrel with it.
No, Your Honor.
Moving to the next paragraph, I also believe that that's from the Form 3.6 instruction. State, any issue with the third full paragraph?
So in my request, I struck through or threatening to use each time because the evidence doesn't support that. What the evidence supports is she did actually use force. It wasn't a threat of force. So I think it's unnecessary, confusing, and not supported by the evidence to have that clause in each of the paragraphs where it's mentioned.
Response, defense.
Judge, I have no problem with that. I was just, when I put it in, I just was going on some statements that the state had made and different arguments. So, especially when I'm talking about aggravated assault.
Okay. So just so that I'm clear, you've got no objection to the removal of that language. So the third paragraph would now read, Sarah Boone does not have the burden of proving that she was justified in justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. Is that correct, state?
Yes, sir.
Is that correct, defense?
Yes.
All right, very good. Yes, sir.
To make it quicker.
And Mr. Henderson, you don't need to stand up every time, sir. I appreciate it.
I'm sorry, but it's old.
I get it.
But it's out of habit. Judge, every time that comes up,
You lose it?
yes.
Understood. So then just let's go back to the title then. Can we revise the title to 3.6F, justifiable use of deadly force, and remove that bracketed or threatened use language?
It should just be used.
Okay, very good. All right. The next sentence, the law on the justifiable use of deadly force is as follows. Is that acceptable? State.
Just the strike through or threatening.
As I read it, yes.
Yep.
Is that acceptable defense?
Yes, Your Honor.
Moving now, Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent A, imminent death or great bodily harm to herself. Is that acceptable to the state?
It's acceptable. Just confirm that they don't want me.
Yes, confirmed, only what would be read would be A.
That's correct.
Okay, all right. Is that acceptable, state, with that understanding?
Yes, sir.
Okay, moving now to the next portion. Sarah Boone had no duty to retreat before using deadly force. I mean, my review of the case law, and I don't recall which one it is that if you're on your own home, you don't have to retreat.
My understanding of the facts was that she used force first by zipping him up in the suitcase and doing so that, one, she could make him feel like he had made her feel in the past for choking and cheating on her, and two, to give her a platform to be able to speak to him as a captive audience, and he would have to listen. Because she took the actions of an initial aggressor, it is our position that there is a duty to retreat caused by the initial aggression, as that is addressed lower in the jury instructions.
Response, defense.
Judge, I have a different view of the evidence. I think what the evidence has said about the initial in the suitcase is that Mr. Torres was getting into the suitcase and positioning himself into the suitcase when Miss Boone came down. There was laughter between the two of them. The suitcase was zipped, and it was a consensual deal. It was a consensual thing. She didn't use any threat or use of force at that time to zip him in the suitcase. Furthermore, during the demonstration and when they were demonstrating the suitcase and the zipping ability, I know time has passed, but I hadn't seen anything different to keep someone in there who didn't want to be in there. If someone didn't want to be in there, it would be almost literally impossible to zip that suitcase because how much force it took to zip that suitcase. So the evidence doesn't support it.
Doesn't support a duty to retreat?
Correct. Because what they're saying, going back even before we had stand your ground, just going back to the Castle Doctrine, there was never a duty to retreat from your home.
So then if I understand your argument, you are not seeking to have this included then?
I am seeking...
Because if you're saying she had no duty to retreat,
that's correct.
This talks about... Hang on, let me just reread it. Okay, so I think I follow your argument. Okay.
What I'm saying is that it should be no duty to retreat, that Sarah Boone had no duty to retreat. That's what we're requesting. I believe the state's objecting to that and saying that it is a dispute, so they want the next paragraph as to the court. But there is nothing that showed at that time, and because the state's arguing that she forcefully put him in the suitcase.
Response.
That's a strong argument. That is not the state's argument. We know what the evidence in this case is. The evidence that she provided was he got into that suitcase by himself and they were playing hide and seek, and he was inside but not completely hidden. The lid was flapping over him. She came over and zipped it shut to whether it's 100% or near 100% shut, and it was all in fun and jest at first. But he did indicate, and we saw it on the video, image IMG_1062, Sarah, I can't breathe, Sarah, I can't breathe. He was being held against his will in that suitcase. That there is no requirement that she initially forced him into it or not. It's no different than two people wrestling and play fighting, and one person has another person in a headlock, and then there comes a point in time where I'm tapping out. Jorge Torres was tapping out, and that's on video, and it's in her testimony. It's uncontroverted. There is sufficient evidence for there to be a dispute as to whether or not she was the initial aggressor, and whether that generates a duty to retreat. And quite frankly, it's undisputed evidence because it's uniquely only her testimony coupled with the video. She restrained him in that suitcase on purpose and intentionally. And if you look at the elements of aggravated assault in our proposed jury instruction, that is exactly what was going on. She intended for him to feel fearful of an inability to breathe, to make it feel like he had made her feel when he had choked her. An aggravated assault is defined as follows: Sarah Boone intentionally and unlawfully threatened, either by word or act, to do violence to George Torres. She would not let him out. She would not release the headlock when he indicated he could not breathe. At the time, Sarah Boone appeared to have the ability to carry out the threat. Well, the video evidence is res ipsa loquitur. He could not get out on his own. He could not get out on his own at 11:12 in the first movie. He could not get out on his own at 11:23 in the second movie. And quite frankly, he couldn't get out at 11:03 during the still photo as well. Element 3. The act of Sarah Boone created in the mind of George Torres a well-founded fear that violence was about to take place. Absolutely. Sarah, I can't breathe. Babe, I can't fucking breathe. Sarah, shh, go fuck yourself. The assault was made with a deadly weapon, element 4. An object not designed to inflict bodily harm may nevertheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Well, ladies and gentlemen, it did cause death. So that's not undisputed. So it's our position that she was the initial aggressor based on her testimony that we received in court, and that is going to put into play a duty to retreat, and that the parties can argue about that.
Anything further, Mr. Henderson?
Yes, Judge. I want to clarify this because what the initial thing in getting into the suitcase, the act is zipping the suitcase up. That act of zipping the suitcase up was not done forcefully. The testimony was he agreed. He was in the suitcase. He was the one who got into the suitcase to begin with. He agreed. The suitcase was zipped up, and there was no argument at that time. All right, and just by the demonstration that they gave, you could see somebody to get in that suitcase or not get out of it at that time wanted to be in that suitcase. And there's nothing to dispute what she says, that he agreed, she zipped the suitcase, and they both laughed and thought it was funny. Now, the next thing that the state goes to is an omission. It is not an act. It is an omission at that point in time where she's saying, when they say, oh, he can't breathe, well, she doesn't go let him out. So they're saying, so they're trying to make that an act when it is not, when she just did not let him out. It's different. And what we're talking about is just the duty to retreat at this time. We're not even talking about the other parts as the thing, but as to the duty to retreat, she's in her home. And at that point in time, when that act took place, she had no duty to retreat.
Here's what the form instruction says. If it is undisputed by the parties that the defendant had no duty to retreat, give the following sentence. Defendant had no duty to retreat before using or threatening to use deadly force. Instruction goes on to read, if the parties dispute whether the defendant had a duty to retreat, give the following paragraph. It sounds like both of y'all, are disputing whether or not there's a duty to retreat.
Yeah.
So I think I have to, based on what the Florida Supreme Court's instruction to me is to give that second paragraph. State, anything further?
No.
Defense, anything further?
Just note the objection, but I understand the court's ruling.
Okay, all right. So the language in the red line from the defense as to Sarah Boone had no duty to retreat before using deadly force will be removed, and I will add in the state's proposed language which tracks the form instruction. Is there any objection? Do you want me to read that to you, Mr. Henderson?
No, I'll read it real quick, Judge.
Okay. And I just want to make sure we're all on the same page. That's the state's proposed revisions to the 3.6F on the top of page 2 of 7.
Yes. I'd ask that the court would read it.
Sure, okay. If Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter for... Okay, I will add that, thank you. For which, so it'll read, if Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter or culpable negligence for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had a right to be, then the defendant had no duty to retreat before using deadly force. On the other hand, 1, if at the time Sarah Boone used deadly force, she was committing an aggravated assault, or if at the time Sarah Boone used deadly force, she was not in a place where she had a right to be, then the defendant had a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid any danger before using deadly force. The law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm or imminent danger of the commission of, parentheses, applicable forcible felony, end parentheses, against herself, and it would have increased her own danger to retreat, or if retreat would have been futile. But if the defendant had a duty to retreat, and if she could have safely retreated but did not do so, then her use of deadly force was not justifiable. I do have a question as to the applicable forcible felony portion of that.
A and B. That's for her, for the A and B that we already previously discussed. Not for the...
That is correct. So then that sentence would be revised to, the law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm, and it would have increased her own danger to retreat.
Yes.
What say you, Mr. Henderson?
Judge, I enter objection as to the instruction, as the state has included to get this instruction an aggravated assault, which is not charged in the information.
State response.
Judge, I'm happy to hop into that one as well.
Okay.
I understand what Martinez versus State says, and I'm sure we've all read the opinion. It's in my motions, and I understand what it holds. What it says all throughout the opinion is there needs to be an independent forcible felony. And then at the very, very end of the opinion, then it says there needs to be an independent felony charged. Why I'm asking for a special jury instruction, and I've made that request in writing, is because under the standard jury instruction that we are going through right now, it says, according to Martinez versus State, that the independent forcible felony needs to be charged. The whole purpose of this is you can't engage into a circular logic argument that defeats Ms. Boone's right to self-defense. So it would be preposterous to include in this jury instruction, Ms. Boone did not have a right to use justifiable use of deadly force by committing second-degree murder against the victim when that's the charged offense. And she, of course, would have the right to use deadly force to defend herself against the victim, and that would be correct. But what we have in this case, and what the state has alerted the court and the defendant to well before trial, was the evidence shows that she committed a separate aggravated assault. She, at the time that she had already zipped him shut in there, and again, just because she releases that quote-unquote chokehold by sitting on the couch, she is exerting that force through distance because she's the one that zipped him shut. So she, in using that force, one who did that on purpose to make him feel like he was choking and make him feel like he had made her feel like when she was getting cheated on, and to intentionally confine him in a place so that she could speak to him about her thoughts. As I already outlined, it's the state's position, and the evidence does support that this is an aggravated assault. She intentionally put him in fear of death, and she relished it. She relished it for that 2-minute video. That is prior to when she says, well, now he's sticking his fingers out and I get scared by that action. And by that action, it's George Torres just trying to exert the will to live and to survive and be on this earth. That now that action, if his attempt to escape out of the suitcase that she has left him zipped up in, is this independent threat of great bodily harm and death to her. She testifies if he gets out, it's her belief that he will beat her up, kill her, disfigure her, so on and so forth. And her testimony at trial, I believe she said was, he said that I will end you. So what we have here is they, by their own admissions, through the testimony that she provided, that there is a separate and distinct independent forcible felony from what ends up being the second-degree murder. What ends up now being the second-degree murder is at this point in time when she says, well, he's trying to get out. I'm afraid if he gets out, I'm going to get disfigured or killed. And so that is why Ms. Boone makes the decision, and I'm not even going down the aggravated battery path, but she batters him with a bat on the hands and batters him, pokes him while he's in the suitcase, and basically beats him into submission so that he stops trying to escape. That's what the testimony was. And then she makes the decision to now leave him and go upstairs and go to sleep without having relieved him from the force that she exerted earlier committing aggravated assault. So like the example I gave you earlier, this is absolutely no different than me pointing a gun at you, Judge, and putting you in fear of your life that I'm going to shoot you and a projectile is going to enter your body and kill you or give you great bodily harm. And you, in turn, after having been placed in fear by me pointing a gun at you, you begin to defend yourself and exert your right to live on this earth by pulling your own firearm. And now, do I, as the initial aggressor, the initial person who committed the forcible felony of aggravated assault on you, under the law, I don't have the right now to defend myself against you. I need to retreat. I need to make it clear, sorry man, my bad, drop my gun and walk away. That is what is the law. 776-041 is a very short and very, very simple statute. And it has not changed since 2014. This has been the law. This was the law at the time of this offense in 2020. 776-041 provides, the justification described in the preceding sections of this chapter is not available to a person who, 1, is attempting to commit, committing, or escaping the commission of a forcible felony. So taking away the firearm example, it's a chokehold. His cause of death, according to the medical examiner, was asphyxiation by position and environmental suffocation, caused by her not releasing a chokehold on him when he indicated, babe, I can't breathe, Sarah, help. That is an independent forcible felony, separate and distinct now from what she says is the victim, like you pulling a gun to defend yourself from me pulling a gun on you. Now, the threatened use of force that the victim is exerting is sticking his hands out and saying, I'm going to end you. That is the distinct break between the aggravated assault and now her continuing to use this unlawful force, which she's not entitled to do because she started it. She was the initial aggressor in committing this aggravated assault. And she ends up just leaving him to die and never releasing the chokehold.
And the unlawful threat is what's on the video in your realm.
Yes.
Okay.
And any facts that support that should cause this jury instruction to be given. The absolute only hang-up about whether or not this jury instruction should be given is because Martinez slightly overstates what is necessary to prevent this circular logic, which is not going to occur in this case. There is not going to be any arguments by the state that she does not have the right to defend herself if she is in imminent fear or death of great bodily harm by the victim. She testified that him sticking his hands out of the suitcase and saying, "I'm going to end you," put her in fear of imminent death and great bodily harm. And in turn, what she did was she decided to not let him out. And he ended up dying. And that is second-degree murder. That is separate than what preceded that. What preceded that was her not letting him out when you can see him pushing up on the suitcase in the video, begging to get let out, and she doesn't because she is doing this out of anger, hatred, ill will, and spite to teach him a lesson and put him in fear of death or great bodily harm. That's an aggravated assault. I would absolutely charge her with aggravated assault and aggravated battery, separate independent forcible felonies, if I could. But I did not learn this information until after the statute of limitations had passed. That is through no fault of the state's. So we absolutely would, if we could, and we are not going to make the argument and defeat her defense of second-degree murder by saying, well, you can't defend yourself with second. I understand what they're getting at in Martinez. That's not this case, though. It's broken down into those parts.
Can I have the citation for Martinez? Because unless I missed it in your motions, I didn't see Martinez cited in the motions.
I'm sorry.
And forgive me if I
No, it's been in previous motions.
Because you cited a Cologne with regard to the Miranda issue.
No, I am referring to, there's a pleading entitled State's Request for Forcible Felony Instruction and Request for Initial Aggressor Instruction, which we've kind of hopped into now since aggravated assault is being mentioned in this paragraph. In paragraph...
Oh, there it is. I apologize.
Yeah, paragraphs 12 through 31 are the legal analysis, and Martinez is cited in there at paragraph 19 at 981 Southern 2nd 449 Florida 2008. And more importantly, what Martinez doesn't say is that there's like some requirement that the verdicts would be interlocking. Like there's no requirement that second-degree murder be count 1 and aggravated assault be count 2, and then if they return a not guilty verdict on aggravated assault, then there has to be a not guilty verdict on the second-degree murder. That's not the case because there's so many different prongs to the self-defense instructions. So it's not required to be charged for some reason of an interlocking verdict. And the whole spirit of that opinion is that it is to make sure that we do not defeat her self-defense argument that she's entitled to make about why she committed second-degree murder. All we're saying is you're not entitled to defend yourself in that manner if you committed an aggravated assault to start this. And that's what the facts show. It's a little complicated, and there's another special jury instruction related to this force by distance. It's like tying somebody to some train tracks and walking away. I mean, are you still choking the person? No, but are they restrained in a manner that if a train comes, they will die? Yes. So the special circumstances of this case and the facts are going to warrant, in the state's estimation, the forcible felony paragraph, and then that language being placed into this initial paragraph that we're talking about.
Just reading Martinez. Give me a moment.
Yes, sir. And then just for the record, the 3 prongs for a special jury instruction, which I cited in a couple of my other pleadings. A special jury instruction is warranted when A, the special instruction is supported by the evidence, which is the case. It's in fact undisputed since there was only one person there. B, the the standard instruction did not adequately cover the legal theory it is meant to. That is also true. And C, the special instruction was a correct statement of the law and not misleading or confusing. That is also the case. Stevens, Stephen's versus State, 787, Southern 2nd, 747, and I mistakenly put 657. I imagine.
I think it's 755 is the pinpoint.
Yep, 2001.
Yeah, I reviewed that already. Thank you. Response.
Response is clear, Judge. They're trying to make exceptions for the law. That doesn't work here. Simply this. What the requirement is under Martinez to get the aggressor is this. It's only applicable and only in cases where the defendant was charged with either an independent forcible felony, that's Martinez, or B, felony murder. That's a different case. And Martinez, they have not charged an independent forcible felony. So it doesn't apply. It tells us right there. That's the standard jury instruction. For him to come back here and say, well, really, Judge, they overstated Martinez. Martinez is still good law. It has not been changed. That's the rule. That's the requirement.
But this is relying, the Martinez opinion states, indeed, consistent with this case law in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. That doesn't seem to be what the new instruction says, unless I'm missing something.
I'm sorry, can you repeat that?
Sure. The sentence says, indeed, consistent with this case law, in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant with more than one forcible felony. And unless I'm missing something, a 3.6F instruction doesn't say that now. The form instruction.
Judge, when it comes to the aggressor in the standard jury instructions, when it comes to aggressor, and they're talking about under 776.041 sub 1, it's to only be given if, and only in cases where the defendant is charged with either an independent forcible felony. You cannot give this instruction unless there's an independent forcible felony that Ms. Boone has been charged with, and there just isn't one.
But where does it say that in the form instruction?
Judge.
Yes.
It's page 14 of 28. Aggressor 776.041, 1, Florida statute, give if applicable and only in cases where the defendant is charged with either A, an independent forcible felony, Martinez versus State, 981-449, Florida 2008,
Hang on.
for the felony. And we're acknowledging that. But when you look at the case and what it is stating is the purpose of that is there has to be in the evidence an independent forcible felony. And that is what occurred in this case. She committed an aggravated assault. After that, the defendant is saying the victim placed her in fear of imminent harm or death by sticking his fingers out and by saying, as he's trying to escape, I'm going to end you.
But unless I've missed something, that's not what we're talking about right now.
I agree, but I think it cohabitates together.
Okay.
And it's our position, we absolutely would charge her. And it's a legal technicality and part of this standard instruction that we can't because of the statute of limitations. We all know, all of us here together as attorneys, know that those facts, if believed by the jury, support that she violated Chapter 776.041, Friend 1. she should not be able to get away with murder because of a statute of limitations technicality that was through no fault of the state's own. The purpose and spirit of Martinez is to make sure that we're not up there arguing, ladies and gentlemen of the jury, she had no right to defend herself from an imminent threat of harm by killing somebody. That's not what we're going to say. We understand that. What we are going to say is, ladies and gentlemen of the jury, she had no right to leave him in that suitcase out of fear and great bodily harm or imminent death because she committed an aggravated assault to put him in that predicament. That's the evidence in the case. That's the arguments that's going to be made. That's why we're making a special instruction request based on the unique facts and circumstances of this particular case.
Give me a second.
Yes, sir.
The language in the instruction in pertinent part says he or she was committing an act, insert the defendant's criminal activity that the defendant act, but the criminal activity cannot be the charged crimes for which the defendant is claiming self-defense or the defense of others. The charged crime is second-degree murder. So I'm struggling with understanding as the other crime is, because I'm not hearing any argument as to the applicability of aggravated assault.
Judge, because, and I didn't make any argument about aggravated assault applying because they can't get over the first hurdle. The first hurdle is it has to be charged. It's not charged. That's what the case law says. I mean, this is pretty clear to me unless I'm looking at it wrong when it says this is not to be given if there isn't an independent forcible felony charge.
Any other response, State?
Just that it defeats the purpose of the statute and is manifestly unjust when it is a legal technicality of no import. There is no interlocking verdict required. If we were able to charge aggravated assault, there's no requirement that they both be found guilty. They could go ahead and hear this instruction and find her not guilty of aggravated assault and still convict her of second-degree murder because of all the plethora of permutations we have in this instruction.
But in Martinez, the underlying charge was attempted murder and aggravated battery, both of which were charged, and we don't have that here.
But it's still going to be the one act in those facts. We are talking about separate, clearly distinct facts here that support there's an aggravated assault that separately gets committed first, and then in response to the victim responding to that aggravated assault, she leaves him in the chokehold to die because if she lets him out, it's her belief she's going to face death or great bodily harm because she committed a forcible felony against him. This is purely a legal technicality. The entire opinion on Martinez, until the very last paragraph, uses this language. They use language like, the underlying facts of the present case demonstrate why it would be illogical to conclude that section 776041, paren 1, applies where there is no independent forcible felony. It doesn't say where there is no independent forcible felony charged. It goes on and uses that same language all throughout the opinion, and then in the very last paragraph in the conclusion, it changes to, in conclusion, we hold that it is error for a trial court to read the forcible felony instruction to the jury where the defendant is not charged with an independent forcible felony. But there is an independent forcible felony in the facts. There is a statute that says that Ms. Boone should not be able to avoid the girth of this jury instruction. She violated, according to the facts that she gave us, she violated 776041 paren 1. She was committing an independent forcible felony and therefore should not be able to get away with this instruction not being given because the technicality that the state can't charge a case or can't charge a count that is not required to be interlocked by verdict. Thank you.
Okay. Footnote 4 provides, explanation in the Martinez opinion as to certain circumstances and whether or not in that hypothetical that the Supreme Court gave, whether the robbery is a separate and independent forcible felony and the forcible felony instruction is applicable. But the conclusion seems to state that it has to be charged, that it is an error for the trial court to read the forcible felony instruction to the jury where the defendant is not charged with the independent forcible felony. Anything else, Mr. J?
No, sir.
Then how do we want to accomplish this? Because I don't know how I can read proposed language by the state, and there's a disagreement as to whether there's a duty to retreat. It's not undisputed. It is, in fact, disputed.
Well, their complaint is in the sentence, on the other hand, if at the time Sarah Boone used deadly force, she was, and I just think we strike through committing an aggravated assault. We go to, if at the time Sarah Boone used the deadly force. Okay.
And unless you just want to go to 2, on the other hand, if at the time defendant used deadly force, she was not in a place where she had a right to be, then the defendant had an obligation to, then the defendant had a duty to retreat, just excise 1 completely. I don't know what else to do.
But she has a right to be there.
Right. Under the Castle Doctrine and the case law.
Okay, then I think we go with the first paragraph and then we just deal with the initial aggressor at the end, which is kind of the exception to that. So,
Okay, so then Sarah Boone had no duty to retreat before using deadly force.
Yes.
Okay, is that acceptable to the defense?
Yes.
I think it puts us back in the position where we started at anyway.
Yes.
Okay, all right.
I just object for the record in case some assistant attorney general wants to potentially cross appeal something.
Objection noted. It looks like the next parts of the form instruction, if the defendant was in a dwelling, was excised, the give A, B, or C was excised. Are you on board with that state?
Yes, sir.
Then the next paragraph, a person is not justified in using force to resist an arrest. Clearly that's not applicable. I don't think that's at odds. However, if an officer used excessive, I also don't believe that's applicable based on the facts. We then proceed to the give in all cases language. Any objection to this language state? Sure. It's the bottom of page 2 of the defendant's 3.6F red line.
I'm just finding where it's in
On the form instruction, it's the bottom of page 3 of 7. Given all cases, right after Jackson v. State.
Yeah, just the agreed upon strike throughs of or threatened use. So just being deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time.
Any objection?
No objection to that, Judge.
Okay. We'll excise the threatened use, so it'll all read use of deadly force in that paragraph. All right. Now we have a proposed instruction, I believe, from the defense regarding battered spouse.
We table the battered spouse proposed instruction since both parties have that?
Sure. Moving now to the presumption of fear, that's been struck out by both parties and agreed to. Moving to the exceptions of presumption of fear, that's been struck out by both parties and not necessary. That takes us to a person who unlawfully by force enters or attempts to enter, that's not applicable. Definition of dwelling is not applicable. Residence and vehicle are not applicable. That takes us now to the aggressor language.
No additional arguments as to why the facts show she was the official aggressor, and thankfully for the state, there's no requirement under this provision that there's an independent forcible felon.
Okay. Looks like we have a disagreement between the parties as to the application of the aggressor instruction. It's struck out on the defense's side and not in the state side. What say you, Mr. Henderson?
Give me 1 second.
Sure.
Please.
Yes, sir.
Right. Are we on 776.041 sub 2?
Yes, sir.
Okay. If I could have one more.
Yes, sir.
Judge, my argument would be that the only evidence, the evidence from Sarah Boone stated that she did not do anything forcefully wise until after Mr. Torres had made verbal threats and was coming out of the suitcase. So
That's, my objection is based on that. No other legal argument.
Any other argument? State.
Just judge, it's play wrestling and not releasing the chokehold when your buddy taps out.
And, I mean, isn't there evidence as to what Ms. Boone had told the experts, which seems to be at odds with that issue, and it's really a factual issue and a determination for the jury to make that determination on what the real facts are?
I can't disagree with that.
Okay. Then with regard to the proposed language as the 776.041 sub 2 instruction, however, the use of deadly force is not justified if you find that Sarah Boone was attempting to committing, or escaping after the commission of aggravated assault. An aggravated assault is defined.
No.
No?
Yes.
Am I on the wrong section? I apologize. I am at the wrong section. Forgive me. So it is the, however,
With my strike throughs is, however, the use of deadly force
is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself unless, 1, the threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George, that's spelled incorrectly, Torres, or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres as clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of force.
Yes, sir.
What's your just for clarification purposes, anything else as to that instruction defense?
Just one thing I need to put on the record, Judge.
Yes, sir.
The force at that time, as testified to, was the poking of the bat on the outside of the suitcase. There was one strike when the hand was outside. These were bruises. I think there was something that came to the injury to the head area, though. The injury to the head could be serious, but in this instruction, it's talking about deadly force. And none of those, as to the testimony from the medical examiner, none of those injuries caused the death.
But the continued restraint on him that she did not undo is the force that we're talking about. It's just like in the cases that I cited in my special state's request for special jury instruction regarding withdrawing from physical contact. Batteries don't need to be skin to skin. You can commit a battery on somebody while driving your car and striking their car. A false imprisonment does not mean you have to choke somebody. You can falsely imprison somebody by barricading them into a room with a grocery cart. She unlawfully exerted that force and did not withdraw from using that force when her wrestling partner, so to speak, tapped out.
Okay. I'm going to include the instruction for now. The next paragraph reads, if you find that Sarah Boone, who, because of prior threats or difficulties,
No objection from the state.
all right, that'll be included. The next paragraph, if you find that at the time of the alleged aggravated assault and or criminal mischief.
Yeah, there just needs to be secondary murder, manslaughter, or culpable negligence, and we don't object. There were specific acts put into evidence.
Any objection to changing the beginning of that sentence defense if you find that at the time of the alleged murder in the second degree, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act?
Yes.
Okay, thank you.
We requested the strike through at the end or threatened to use.
Agreed.
Give me a moment. So that sentence would now, or that section would now read, if you find that at the time of the alleged second degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Acceptable?
Yes, sir. I just don't know that we use Junior after his name anywhere else.
Give me a moment. Yeah, Junior's not used anywhere else, so I'll excise that. Is that acceptable to you, Mr. Henderson?
Yes, sure.
All right, moving to the next line. If you consider that George Torres, removing Junior, had a reputation for being a violent and dangerous person. I don't know, did we hear evidence of reputation?
The state's position is going to be there's no reputation evidence. Ms. Boone offered an opinion, but as everybody knows, reputation evidence has to come from a broad enough aspect of the community, whether it be a church or a neighborhood or perhaps even a large family. But
Defense?
I'm rethinking that, Judge.
No worries, take your time.
I know generally, and reputation evidence, generally, it has to be something that is known based on a community standard, and if that was the community. I know the only thing that I can relate to is the fact that individually, she experienced certain things that could build that reputation, but that's unheard. I think there's evidence, though, from people, at least that they knew about it or were told about it. Most of that was stopped. But I could go to at least the one situation on a text message that was introduced earlier today that talked about him beating his former wife or ex-wife.
How is that reputation? Yeah, it sounds like that's a specific instance based on that text message.
Correct. I agree.
Okay, so in agreeing, we're going to excise the reputation section, correct? Okay, thank you. The court will excise that.
the state agrees to the physical abilities that's mandatory in each case.
What about the one that precedes that? If you find that George Torres had a reputation, well, also that reputation would be removed as well, correct, Mr. Henderson? If you find that George Torres Jr. had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor.
That's correct.
Okay, so that'll be excised as well. State has no objection to the physical ability section. I'll just remove the word junior after Torres. Any other questions with regard to the 3.6F instruction?
Your Honor, the state doesn't object to what we have produced as the final product. I'm impressed we did it so quickly. We just note our objection for the record to preserve a challenge to Martinez's opinion.
Understood. Do the parties, well, let me ask this question. Mr. Henderson, anything else we need to address with regard to the 3.6F instruction?
No, sir, I'd just like to preserve the objections that I made during this conference.
Objections preserved. Do the parties wish the court to reread the 3.6F instruction that we just went through, just to make sure we're all on the same page?
Yes, sir.
Can we do it at a time where it
is in final form? Yeah, absolutely. Okay.
Perhaps a written copy that we can take during the snack time?
Sure, absolutely. All right. Where does that take us now? Does that take us to the 3.6G instruction?
I believe so.
Okay, give me a moment. I have the state's proposed 3G instruction. I have the form instruction from the Supreme Court. And I have the defense's proposed revisions. Just move everything around here. Give me a second. As to the title, I believe that based on what we've discussed, the "or threatened use" should be removed. Is that correct?
That's correct.
All right. As to the first sentence, it is a defense to the crimes of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of threatened use, as we're removing justifiable use of non-deadly force. We're removing threatening, and we would also be including manslaughter, correct?
That's correct.
State?
Yes, sir. It is a defense to the crime of second-degree murder, manslaughter, in Oxford, or culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force.
I, too, am a big fan of the Oxford comma. So the defense would, or the instruction would now read, it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Acceptable, state?
Yes, sir.
Acceptable, defense?
Yes, sure.
Definition of non-deadly force is not at issue. Next paragraph. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. Acceptable, state?
Yes, sir.
Defense?
Yes, sure.
The law on justifiable use of non-deadly force is as follows. Sarah Boone was justified in using non-deadly force against George Torres, excising Jr., and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against A, George Torres, excising Jr., imminent use of unlawful force. Is that instruction acceptable?
Yes, sir. I don't know if you mean to include the A if we're not using the B. I would just suggest you make one sentence.
Any objection?
No objection.
Okay. Any other issues with the instruction as read so far? State?
No, sir. Thank you.
None,
Defense?
Your Honor.
Okay. Looks like there are several agreements with the balance of this instruction as to the defense of property is not applicable, the 776.0134, dwelling in residence and vehicle, and force with regard to law enforcement, all of which is not applicable in the instant case. That takes us to the give in all cases. We would be removing the threatened use of non-deadly force in that section. Any other changes is to the give in all cases section.
Not from the state. Thank you.
Defense?
None, Judge. No objection.
All right. Okay. Let's table the proposed instruction on the battered spouse for the moment.
Then the state will be making its request for the forcible felony instruction.
Under Martinez.
Yes, and we understand the court's ruling, and we're sending a strongly worded disagreement to the court, Supreme Court.
Received and understood, but based on what the court said earlier as to the conclusion in the Martinez section, I'm disinclined to add your proposed instruction.
I understand why.
That takes us now to the 776.0412 section. Looks like we have a little bit of a disagreement here. Is it the same arguments that we received in the 3.6F instruction?
It's the same fact.
Any other additional arguments, sir?
No, Your Honor.
All right. For the reasons previously identified, the court will accept the state's proposed portion as to the 776.0412 instruction. Then it takes us to the prior threats.
Same requests and objections as in 3.6F from the state, sir. For the end of the instruction.
I agree that it should track with the...
Forgive me. Other than reputation, What were the other issues?
Prior threats should come in.
Mm-hmm.
Specific acts should come in.
Okay, thank you. Reputation should be excised.
The 2 paragraphs of reputation excised, and then physical abilities gets read in all cases.
Agreed?
Correct.
Okay.
Great.
All right. And then we'll remove the threaten language in there, correct?
Yes, that's correct.
Give me a moment. Okay. Any other questions with regard to the 3.6G instruction state?
No, thank you, sir.
Defense?
None, Your Honor.
Okay. I believe then, just double check my notes. I believe then that addresses those issues based on what we did not discuss this morning in the charging conference. And I think that now takes us to the state's requests and the defense's request for special instructions.
Can we do the battered spouse one first? Conflicting requests.
Yes. Specifically, we're making reference to the state's request for special jury instruction regarding battered spouse syndrome filed, I believe it's not dated, but I think it was either the 23rd or the 24th that you filed these, Mr. J, and the court record will speak for itself as to when they were filed. Okay. Courts reviewed that motion and reviewed the proposed instruction by the defense. State, let me hear from you first.
With their instruction, I think the problem with it is that it kind of blurs the subjectivity component versus the objective reasonable person standard. So if we make this change to their instruction, then I'm actually okay with it. What I would suggest that change be is in the second paragraph. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by the victim, no junior. I don't know if it's necessary with the date. That makes it clear, because that's what the case law says. The case law makes it very clear it's about the objective component.
I agree with you.
And then I would just ask for my last sentence, which is like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse.
Let's say the defense. And if necessary, I can read.
Yes, could you do that?
So it looks like there's no, first of all, just so the record's very clear, Stevens v. State identifies the special instruction circumstances. Special instruction is supported by the evidence in this case. Yes, absolutely. The standard instruction did not adequately cover the legal theory it is meant to. There is no standard instruction on battered spouse over and above what's included in the self-defense instruction. The special instruction was a correct statement of law and not misleading or confusing. We're addressing that third prong of Stevens at this time. The proposed instruction would read, you have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. It would then go on to read, like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome.
Agreeable.
Okay. Appreciate y'all working together on that. Give me a moment to finalize this. As such, the third prong of Stevens has been made, and the court will give the special instruction as identified on the record. Now, the only question I also have is, do we want this as its own instruction, or do we want this included where it currently is and the 3.6F and 3.6G instruction state?
I would suggest it be 3.65, right after the two instructions about use of force.
I agree with that.
Okay. Do we want to label it or just have it as special instruction and then read it? Do we want to have the title special instruction on battered spouse? I welcome.
I'm fine with the same battered spouse syndrome.
That's fine.
Okay, so it'll be special instruction on battered spouse syndrome. Is that acceptable?
Yes, sir.
Is that acceptable?
Yes, sir.
All right, thank you. All right. And that will follow after the 3.6G instruction, correct?
Yes, sir.
Acceptable, Mr. Henderson?
Yes, sir.
All right, that takes care of that.
All that should have left. Oh, go ahead.
Yes, I'm sorry, sir.
I'm sorry. I think we might be required to read it both times after each one.
I have no problem with adding a paragraph into it that says this applies to both the justifiable use of deadly force and non-deadly force.
That fixes it.
Okay. Where, gentlemen, do you want that?
After the big paragraph that ends with George Torres and before like any other witness.
Sure. Okay, so let's go over that language one more time so that we're all on the same page. Mr. J, what is it that you propose?
To put between the paragraph that ends with Jorge Torres and before the paragraph of like other witnesses or whatever I said, you can consider this testimony and evidence in the applicability or the use of whatever word people agree on of both deadly force and non-deadly force instructions, something to that effect.
If that's too convoluted, I'm fine with it just being repeated.
I tell you what, I'd rather just repeat it.
I think so.
That gets way complicated. I'd rather just repeat it under 3.6F and 3.6G.
Agree.
Okay. Does that work with you, Mr. Henderson?
Yes, sir.
All right, thank you, sir. All right. Okay. Moving now to the state's request for special instruction regarding withdrawing from physical contact, filed October 23, 2024. Court has reviewed it. I guess the first question is, what say? Is there proposed language?
Trying to see if I'd actually put that in there.
I don't know that I see it, Mr. J.
Oh, paragraph 15. Physical contact includes any restraint on George Torres, apostrophe, movement.
And this would be after the initial aggressor portion and the 3.6F and 3.6G, correct?
Yes, sir.
Okay, what say you, Mr. Henderson?
If I could have one.
Yes, of course.
Judge, this is what I'm having a problem with, but I think it could be corrected. Because they're talking about at this, therefore, at the conclusion of the two paragraphs regarding initial aggressor, it should come in not there, but shouldn't it come in, because that's not there anymore, initially provoked.
Yeah, in the 3.6F instruction, references to initial aggressor have been removed.
Yes. So now is the state asking for it to come in as the initially provoked.
Unless I missed something.
My understanding was that it was the two paragraphs about aggressor are coming in. What's not coming in is the Martinez forcible felony. The facts of the case.
Right, but the language, you said at the conclusion of the paragraphs regarding initial aggressor, the words initial aggressor don't appear in the 3.6F. It's only after that. However, the use of deadly force is not justified if you find Sarah Boone used force to initially provoke the threatened use of force against herself unless, and then it's paragraphs 1 and 2. Is that where you're asking it to be?
Hold on, let me pull 3.
Sure.
You got it here. So in 3.6F, it should be, however, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke.
Correct.
The
That's what I
threatened
have.
use of force against herself unless, parens 1 and 2.
Correct.
And then after 2, as an explanation for what is listed in paren 2 as from physical contact, just that elaboration of what we're talking about.
I got it.
Because the unique circumstances of this case, the remote force.
Okay, I got it. I just want to make sure. I just want to make sure we're all on the same page as to where. What say you as to the proposed language of physical contact includes any restraint on George Torres's movement as that portion in 3.6F and in 3.6G?
No.
Okay, all right. So court's going to grant the state's request for special instruction regarding withdrawing from physical contact. And the language of physical contact includes any restraint on George Torres's movement will be included after the however the use of deadly force language after paragraph 2 in the 3.6F instruction. And in the 3.6G instruction, it will be at the end after the physical abilities section. Also, it's George is spelled incorrectly. That will be remedied.
I thought the two paragraphs about aggressor were being mirrored in 3.6G. It shouldn't go after physical abilities. It should go after.
Oh, I'm sorry. You're correct. I apologize.
No problem.
Okay, got it. That takes us now to the state's request for special jury instructions on causation, filed October 23, 2024. I have reviewed it and the proposed instruction on paragraph 3 therein.
Judge, the reason we're bringing this up is just during the cross-examination of Dr. Z, or Zadovich, we poked the bear a little bit about his cardiovascular condition. My memory of the testimony was that she's emphatic that that was not the cause of his death. But because of that, and because of now the request of culpable negligence at misdemeanor for a lesser, I feel it might be warranted to give this explanation of causation in the second-degree murder and manslaughter instructions.
Defense, what say you?
Judge, I would object. I believe that just the instruction, the proposed instruction that I have it, as one but for the defendant's criminal act, which we have a standard jury instruction that said the death was caused by the criminal act of the defendant, and that's what they're required to prove. This language, to me, would lessen that requirement by saying but for the defendant's criminal act.
Then the second part, when it goes up to George Torres' death, was not beyond the scope of any fair assessment of the danger created by the defendant's criminal act. I think that's covered, Judge, in the fact that the state does not have to prove that Ms. Boone had the intent to kill George Torres. So that makes it confusing to me when the standard instruction basically simplifies it, in my mind, and it keeps them right where they're supposed to be with that instruction. They don't have to prove that she had the intent. Then, as to the third part...
I'll withdraw my request for that.
Okay.
If heart disease gets brought up in closing,
All right, fine. So withdrawn. Court takes no action on the state's request for special jury instruction on causation. That leaves us now with the state's request for forcible felony instruction and request for initial aggressor instruction.
That's already...
That's already been addressed, has it not?
I was just treating it as a special jury instruction for my argument.
Understood. All right, are there any other instructions sought by the state at this time?
I believe we have concluded this exercise.
Defense.
No other ones.
All right, here's what I'm going to do. I'm going to take all this upstairs. I'm going to re-review it. I'm going to merge it all into one document, and I will send it to all the parties. Let's plan on being back here at 1:30, and we'll address any other concerns of the jury instructions at that point in time. State, anything else we need to address?
125.
Well, let's make it 1:20.
All right, thank you.
All right, defense.
Nothing else.
All right, we'll see you all at 1:20. Thank you.
Hey there, trial watchers. This is a law and crime legal alert. A mother was recently awarded millions of dollars in a lawsuit against baby formula manufacturers after her premature baby was diagnosed with necrotizing enterocolitis or NEC after receiving bovine-based formula. The lawsuits allege that Enfamil and Similac premature formulas, they are linked to NEC, but manufacturers, they failed to warn the public of the risks and targeted them with false advertising. So if your premature baby was diagnosed with NEC after they were fed Enfamil or Similac, you may qualify for compensation. And one of our legal partners is partnering with Wagstaff Law Firm, a national firm renowned for their expertise to ensure that eligible claims are thoroughly presented. Just visit babyformuladamages.com/YTT.
Thank you. Very strange. It is not letting me copy it over, and I don't know why. Correct. Was there anything else other than that? If you find George Torres had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor. Anything else that needs to be added to the jury instructions from the state side of the ledger?
Well, the reputation should be deleted.
Correct. I agree with you. Yes. I'm sorry. What the heck is going on here?
No reputation, Judge?
That's correct.
What does that state exactly? Is that all of it?
Mr. J, was there another line that we had added to the end of that?
I don't believe so. The physical contact sentence is where it should be.
Okay. Maybe that's what I was making maybe that's what I was thinking of. So the sentence should read, in considering the issue of self-defense, you may take into account the relative physical capabilities and capacities of Sarah Boone and George Torres. Is that correct?
Yes, sir.
All right, thank you.
36F.
Correct. It matches 36F now. I apologize. I'm going to have Madam Clerk, I'll email it to her now, have her print out pages 25 copies of 12 and 13, and we'll start taking apart our jury instructions and re-adding them. And I thank you for your patience. 12 and 13, that's it. Mr. J, are you going to be utilizing the verdict form in closing?
I am not.
Mr. Owens, are you going to be utilizing the verdict form in closing?
I may. Where is it going to be at your bench?
Yeah.
I'll ask you for it if I need it.
Very good, sir. Thank you.
Judge, and when you get a chance.
No, go ahead, sir. I can multitask.
I know there's a mic here. I know there's a mic right here.
I will confirm with court admin that microphone is on. I believe it is. They turned it on during openings. I'll confirm now.
And then, Judge, last time I used this fingerprint table as my podium.
That's fine.
I may just slide it back so I'm...
That's fine, sir.
And then, Judge, I've got 2 tripods. And I've got some demonstrative aids. One is this, it was originally a quote by Dr. Michael Brannon.
Judge, objection.
Okay. May proceed. What are the other enlargements, sir?
It's the one I tried to get in.
I hear no objection.
An opening, which was the justifiable use of non-deadly force.
No objection.
You remember my reasonable doubt? I was using it for.
You've seen them?
I had no objection to those 5. I didn't like the 3 charts. The defense agreed that we found reasonable doubt charts they won't use, so I think we're all good on your charts.
All right, very good.
And the only other thing I'd want to use.
But we're good with their demonstrative aids during closings that we were used during trial.
Okay, very good.
I've got 2 videos that I'm going to want to play, and Shelby Andrews is going to walk up.
And they're in evidence, right?
Yes. They are.
Yep.
Okay.
One of us has been pared down.
That's fine. As long as it's in evidence, you can present whatever you'd like.
And Judge, do you want to talk about time for closing?
We can. What do you think, State? You advised an hour and a half.
Yeah, I think we both said an hour and a half, but as the court knows, you can't really hold us to it until it gets a little ridiculous.
That's true. How much do you anticipate, sir?
Well, Judge, she's charged with murder. We've had a 2-week trial. I've got a lot to say. I've got a lot of notes.
We're good. Go.
Say again?
I'm not hearing any,
Okay.
stammering clamoring from the state.
After the state has had their first opening, give them a
Agreed.
short break, and then let me start.
Agreed. We'll take our afternoon break at that point in time, then we can proceed with the defense closing and then rebuttal. I have received approval from the chief to work after 9 o'clock. So we can go till about 10, maybe a little bit thereafter.
And then you're saying with the jury. And
Correct.
Then at 10 o'clock, if we hit some number, 10 or 11, then we would come back Monday?
That's correct. second-degree murder.
We're ready, Judge.
Let's go ahead and bring in our jury. Yeah, that would be fabulous. Bruce. I do not. The jury. Awful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 3.4, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of second-degree murder is manslaughter, culpable negligence. 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. George Torres is dead. 2A. Sarah Boone intentionally committed an act or acts that caused the death of George Torres. B. The death of George Torres was caused by the culpable negligence of Sarah Boone. Yes? I apologize. Or, thank you for that clarification. Sarah Boone I'll reread those for you. 2A. Sarah Boone intentionally committed an act or acts that caused the death of George Torres. Or B. The death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life, or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. 8.9. Culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1. Sarah Boone exposed George Torres Jr. to a personal injury. 2. She did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life, or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such indifference to the rights of others as is equivalent to an intentional violation of such rights. 3.6D, as in Delta, voluntary intoxication. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. 3.6F, as in Foxtrot, justifiable use of deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use, deadly force, is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat before using deadly force. In deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself, unless 1. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. Please silence your cell phones. And had it exhausted every... Out. Whoever phone is on, get out right now. Members of the jury, I apologize. I'm going to read that over for you for the beginning. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
Judge, I'm missing page 10 and 11.
I am too.
Okay. We will remedy that. Thank you, sir. Is it just your copy, Mr. Owens?
Anybody else missing 10 and 11?
Mr. Owens, approach, sir. Yes, sir. Thank you. We'll bring it to you, sir. And we'll wait till you have those, sir, and we'll continue. Thank you. Thank you. Record reflect all thumbs were up. Page 11, special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.6G, justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. The law on the justifiable use of non-deadly is as follows. Sarah Boone was justified in using non-deadly force against George Torres and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against George Torres's imminent use of unlawful force. In deciding whether Sarah Boone was justified in the use of non-deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of non-deadly force was necessary. Moreover, a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. However, the use of non-deadly force is not justified if you find that Sarah Boone used force to initially provoke or threatened use of force against herself, unless the threatened force asserted towards Sarah Boone was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on George Torres. Or, 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and indicated clearly to George Torres that she wanted to withdraw and stop the use of non-deadly force. But George Torres continued or resumed or threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who, because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and/or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.7, plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9 Bravo, defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1. Whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2. Whether anyone had promised her anything in order to get her to make it. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. 3.10, Rules for Deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this matter. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. 3.11, Cautionary Instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. 2.7, Closing Argument. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. With that, state, you may proceed.
This is a box. This is the box where George Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. George Torres was zipped up in this box. George Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath George Torres took in, there was less oxygen in this box. George Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So, as we start out here on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because George Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs, and it reads, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident and in misfortune, in doing any lawful act by lawful means, usual, ordinary caution, and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when George Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And and that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. George Torres couldn't provoke anything from his circumstance. George Torres was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, the killing is not done in a cruel and unusual manner. Well, this fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking and we're all having fun, but she decides that it's going to get a little extra real for George Torres. And it fails on the second count because George Torres was killed in a cruel and unusual manner. Next, we turn to our main charge of second-degree murder. And the law informs us that to prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. And I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of second-degree murder. One fact that conclusively proves each of those elements beyond all doubt. Well, we have a stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. And it's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or a series of acts that one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays an indifference to human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you, ING 1062, and states 17. Mr. J, may you publish states 17?
Sarah. For everything you've done to me. Sarah. For everything you've done to me. Sarah. Fuck you. Sarah. Fuck you. Sarah. Stupid. Sarah. That's my name. Don't wear it out. Sarah, I can't fucking breathe, babe. Seriously. Yeah, that's when you do and you choke me, Sarah.
You may continue.
Sarah. Sarah. Sarah, I can't breathe, babe. That's on you. Sarah, I can't breathe. It's on you. Sarah. Real ransom. Now you want to give it for it extra. Because I got this. Sarah. Real ransom. Sarah. I can't breathe, babe. Oh. That's what I feel like when you drink on me. Sarah. Fuck you. I can't breathe, Sarah. Yeah. You should probably shut the fuck up.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions. But we know from the evidence that this was not the first time she had considered killing George Torres. We know from the evidence that on January 13, 2020, approximately 1 month prior to George Torres' murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. And bless you and all of you too. I'll get rid of him. Then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that George Torres was murdered, and that maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise, and he is going to show you this. And this. And this. And he's going to talk in this as well about the list of grievances that Sarah Boone had for George Torres. He's going to talk to you about curtain rods. He's going to talk to you about black eyes. He's going to talk to you about what an awful, awful boyfriend George Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it, hide and go seek time. George gets into the suitcase. She comes and zips him up. They were still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own playing force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. He couldn't exert anything, ladies and gentlemen. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his... Judge, I object.
Approach. Objection overruled.
This is no help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything. George Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us, again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the special instruction on battered spouse. You have heard evidence that Sarah Boone suffers from battered spouse. You may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we've heard from 3 experts in the areas of battered spouse in this case. And I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that George Torres at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did these awful bad things, that now through the rest of time she's a battered spouse and she just has the right to kill him or to make him suffer or to punish him or to make him feel uncomfortable or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does, it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical. Dr. Brannon talked about rules that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. And her opinion was much more straightforward. Remember, Dr. Brannon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brannon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because George Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
I'm going to go to court and I'm going to tell the judge, listen, my fiance has nothing to do with this. It's all my fault. We were both drinking and got out of hand. It was an isolated situation. It has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments. But we are not the type of people that you guys are portraying us to be.
She especially.
Especially her. So please, if you can,
Dismiss
this case.
Closed.
Drop it. She is not the type of person.
Good person.
She's a great person.
Angel.
I know she'd be an angel.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet.
What?
And it good.
Good, I love you, baby. Whatever you want me to say. God will prevail, and He will take us out of this situation. Love you.
Clearly, George Torres is dominating the defendant. Clearly, George Torres is the one telling the defendant what to do. Clearly, George Torres is the one calling the shots at 4748 France Lane. Ladies and gentlemen, are we so sure that George Torres wasn't the person suffering from battered spouse syndrome. Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed that the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing George Torres, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, you published from States 17, IMG 1063. It was a short video. But what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later, from the time that started, we see that the makeshift coffin that he's in has been moved. And his voice now is softer. The life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only George Torres. In this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. George Torres and Sarah Boone. But only Sarah Boone ever walked out of that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not George Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next interview the next day with Detective Kopsel and Detective Lowen, and more details come out. Things change. First, she was never intoxicated, then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt when she described using that baseball bat to hit George Torres's fingers back in the suitcase when he attempted to save his life? Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of George Torres being murdered and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone? After seeing the videos of how she controlled and manipulated George Torres? And if you say, Mr. Cacciatore, I still have a doubt, well then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt? A speculative? An imaginary? Or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. And do not have any discussions among yourselves or anyone else. We'll bring it back in about 15 minutes. Thank you very much.
All rise for exiting.
Y'all may be seated. Thank you.
Judge, I've got a motion.
Okay, may proceed.
Sarah Boone's entitled to a fair trial. I think that right has been compromised here today. I don't know who scheduled to put the two detectives on the front row with the Torres family, who the family of the victim. But they had to have known to tell them that the Suitcas video, which has been around for 4.5 years, was going to be played during opening statement. And the state attorney's office or the sheriff's department had to advise them, or the victim's advocate had to advise them, that if they couldn't take it in front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen. There should be safeguards in place. There's no room for this after 2 weeks of a murder trial for something like that to happen. One of the Torres members of the family audibly, during the 2-minute Suitcas video, expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain. The physical pain followed the audible announcement. You can't unring that bell. That's their responsibility to ensure that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has a right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it. She clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the courtroom. But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated, and it does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors, so the motion should be denied.
Motion's denied. Jury's going to be back in about 13 minutes, counsel. So we'll reconvene at that point in time.
Could the state put the Suitcas back?
Yeah, can we clean the well from the state's materials, please? Thank you. we are back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Ketchner on behalf of the state. William J. for the Florida, state of Florida.
James Owens for Sarah Boone.
Captain Beck on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
Ms. Boone is still seated at counsel's table wearing the same clothing from this morning. Are we ready to bring in our jury for the defense closing at this time? State.
Yes, Your Honor.
Defense.
Judge, I would like you to give the audience an instruction, and then if you would, instruct the state attorney to instruct whatever family members or friends of George Torres may not be in here and may not be able to hear the instruction, but may come in during the trial so that we can try to get some order.
Are there any other members of Mr. Torres' family that may be outside that may be joining us? Okay, all right, so she's left, she's no longer here? Okay, that's what I just asked. Is there anyone outside? Okay.
She's outside, but she's not coming back.
Okay, all right. So, members of our gallery, good afternoon. I'm going to please ask you to please contain yourself and not to have any emotional outbursts. We had a minor one, and the person, whoever it was, had a small outburst, then hid next to another family member, and then excused herself during the last during the closing. It seemed to be minor in nature. However, I'm advising everyone that at this time, if you believe that you cannot control yourself or your emotional responses during the defense's closing argument or any rebuttal by the state, I'm going to politely ask you to excuse yourselves at this time. All right, thank you very much. Mr. Owens, anything else, sir?
No, sir.
All right, state.
We're ready.
All right, let's bring back in our panel.
They're making their selections.
Okay, thank you. All can be seated. They're making their dinner selections. We'll just give them a couple minutes to do that. Thank you.
from Jay.
Okay.
I was just, I don't know if that is allowed by the court or.
Anything?
Been allowed since I started practicing in 1997.
If you want to split up your closing between the two of y'all, that's fine by me.
Well, I intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask him to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
If it's a discretionary issue, I'll leave it up to you, sir, on what you want to do and how you want to present your closing.
Object during rebuttal.
Reasonable. Who would be objecting during rebuttal?
Mr. Owens.
Okay, there you go. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. Y'all may be seated. Members jury, for one of the last times, if you could, please raise your hands to confirm that you complied with the court's instructions. All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County, it's northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The team, the defense team, is here, and we're here to represent Miss Sarah Boone. And we feel confident that we're going to be able to show you why she's not dead. Okay? And I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you. And then we got a couple of videos at the end. Okay? And we're going to try our best to help you make the right decision. Okay? But yeah, Milton's a small town.
Objection. Relevance.
Overruled.
I'll tell you how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. Very small town. We didn't know what to expect coming down here to Orlando.
Relevance.
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it, but I wanted to say, it's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised.
Objection. Improper argument.
Mr. Owens, approach. Objections overruled.
All I wanted to say is just since we've been here, we've been treated with respect and hospitality, and just like we've been at home. We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack. And you are the only ones, in this case, because Sarah Boone was arrested, that's going to be able to look at it critically and objectively. Objectively. Not like the state attorney.
Objection. Improper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial. And some of the things they said.
Objection. Objection. May we motion?
Yes. You may proceed. Objections overruled.
Thank you, Judge. They've got their side, their position, we've got our side. So we're going to talk about that. But, and we're going to talk about justifiable use of deadly force and non-deadly force. But either way, however you rule, it still justifies her behavior. And the result is not good. Now, I don't believe there's anybody...
Objection, proper argument?
Overruled.
Objection to reproach?
Yes.
I think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is George Torres. The reason for the trauma is George Torres. From the positive things about the man that we've seen on video, to the positive things Sarah Boone has testified about, to the violent monster he becomes. And I mean monster, because it was repeatedly. And what happens the next day? Man, I don't remember. I was drunk. I don't remember. That's the gaslighting. That this young woman, vulnerable woman, with nobody, just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life. Day in and day out. Day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony, but she spoke about some of the veterans that had been in the war in Iraq, you know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime, or police officers will get post-traumatic stress. And a lot of them come in, the males come in with just bravado, I'm all right. I'm all right. And so, that's why Dr. Harper was talking about the veterans, that's what they'll do. But you've got to spend time with them. It just can't be one session. And you've got to run post-traumatic stress testing which tells whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time. Right? Time heals. Right? These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals. Everybody, it helps. Just time. Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break. No break. Learned helplessness. Just giving up. Just giving up. I can't get out of this situation. They broke up. She'd go about 2 days. She'd go about 2 days. Texting and calling. Just learned helplessness. And it's, in the manual. Battered spouse syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind. And it's repeating itself. It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply. Someone in Sarah Boone's shoes, when you're deciding whether her conduct was reasonable. Got a bunch of notes. Something I wanted to read. Where'd that put it? Sarah Boone's long-term exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. George Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the Suitcas video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand. Sarah Boone, being emotionally and psychologically broken, His actions may have been misguided attempts at survival, but not murder. Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon, you remember him. He was the first expert on trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma, that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to me. It changes your behavior, not only your behavior, but your thinking. Your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception. Okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out, you fall asleep, passes out. But it may turn, by depending on his mood. I don't know if you can tell, she would try to placate him. Dr. Brandon said, you know, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now, I want to go on. Trauma experts explain how victims' reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, George Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone would argue with him, talk down to him. Some would say was somewhat abusive to him. Sarah's not charged with that. Sarah Boone is not charged with that. And I want to read you something on that subject. If I can find it. Essentially, I don't know where it's at, but I'm going to have to come back to it. But essentially what it said was, eventually been a 2-week trial. I got a bunch of notes. I'm trying to get this right. I know it's important. What I wanted to say was someone can be mean and angry and hateful and intoxicated and still be abused. They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive. Sarah Boone intentionally left George Torres in the suitcase, which was the act of a battered spouse syndrome woman. She went up to her room, she fell asleep, and passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear, that's real trauma that she was experiencing at that time. Now, I talked to you about force being used, and I think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I got a couple of examples that may or may not apply. Let's say you're in a bar and you've got your buddies and the other guy's got their buddies and they're drinking and it ends up being an argument between two of them. And you realize that these two are fixing to get in it. Well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint where you grab him by the neck and try to get him out the bar. So yeah, you're committing an act, but it's designed to defend another, which is legal. Or let's say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he goes to a call where there's a suspect that may be armed. A suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around. Of course, he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect, and the suspect reaches for his waist. Now, in that moment in time, that officer has to make a decision. Am I going home with my family tonight? And I asked Dr. Werner about this basal instinct. It's called fear response or fight or flight. You know, those decisions are made, it's instinctive. Based on your set of circumstances, she instinctively reacted to her unique set of circumstances to save her life or save herself from another one of these. I'm 63. I can't imagine that. I can't imagine that. Her father's not around. I need to talk about the case a little bit. And if you'll remember, I'll get back to it. If you'll remember, that's what place we did. Let's start with the witnesses, and then I'll talk about second. But the first witness out of the box for the state, if you remember, was Juan Torres, the brother. Remember that? It was some time ago. I know it's been a while. Y'all taking notes. You may have to go back. Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us. Remember Tony Henderson with the cross-examiner of Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me. Mr. Henderson said, did that surprise you? Juan Torres said, no. That family knew what was going on. The police knew what was going on. The neighbors knew what was going on. Pearl Walker came in here, 80-something years old, in a wheelchair. Kevin Beck called her up. She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from battered spouse syndrome. Wouldn't admit it on direct. Well, maybe. I don't really know. I hadn't had enough time to really see her. You hadn't seen the pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time. And she's going to start testifying about stuff she's never said before until she showed up in court. About, well, based on what she told me, I don't think she was in imminent fear. Come on. This is a courtroom. This is a courtroom. Good thing y'all are here. We thank you. But it gets even worse than that. It gets even worse than that here in this courtroom. The state attorney referred to these pictures. And I was going to rise up and show these pictures to you.
Overruled. You may proceed.
And I was going to rise up and show these pictures to you. Well, yeah, I'm going to do that. They put her on trial for murder. But what did they say? And I got to turn to this. Make sure I get this exactly like they said it. I took a bunch of notes. Let me make sure I got this quote. Can't even find it. But it was something to the effect, maybe George Torres is the battered spouse. Can you believe it? Can you believe that? Now you know why we're here. Now you know why we're here. Little boys learn early on that girls are different. You do not put your hands on a girl. You can't wrestle with them, you can't punch them, you can't kick them. You can't treat women that way. When you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman. No, sir. What has the state attorney tried to do?
Objection, proper argument.
Sustained.
What has they done?
Objection.
What evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah as? What evidence? Controlled and manipulated were the words they used. You know, this ain't the 1900s. This is 2024. What's all these text messages? Why is that relevant? What are they trying to claim? She provoked his violence? She provoked his violence. Isn't that what they've done here in this trial?
Proper argument.
Sustained.
And we'll get back on this. Abraham Marino. I don't know if you remember him. Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out, and some neighbors were coming around, and there were 2 or 3 neighbors sitting around. He said Sarah came out and stated it was an accident. Okay? Well, then, it was an accident. And this, Abraham Marino knew George Torres from Philly. Okay? They were friends. They would talk either at the complex, or if Marino went to Hall's Ace Hardware, or Ace Hardware, what it's called. The state attorney notifies.
Judge, I'm going to object to reading from things that are not in evidence.
Approach. You may proceed.
So for 4.5 years, Marino says, all I heard Sarah say that afternoon was it was an accident. And then he came in here today, or this week, and said, no, she said I was teaching him a lesson, things got out of hand, and then I fell asleep. 4.5 years later, we know he's friends with the Torah. We heard it here. Now, I want to talk to you about the two boys that live right next door. You remember Vincent Battaglia and Brandon Motes? Remember those guys? And you remember it came out in the testimony, this event happened on February 23rd of 2020. But it came out in the testimony that Sarah had said, George Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment from top to bottom, which is consistent with what they were saying happened, remember? But they got their dates wrong. And remember, Mr. Henderson called Detective Copsel up in our case, and she had to say, yeah, I didn't take their two statements until the 27th. February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got that the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying? No, that was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, I can't remember now who it was. One of them. And, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't hear anything more of that. Remember? And then this photograph, which we introduced, which shows the bottom of the stairs. As you can see, there's Lucas's bookshelf right here. This is where Sarah Boone stored Lucas's stuff. And you can see it's not disturbed at all. Anyway, I want to get back to Sarah, and I want to talk a little bit about that. But let me talk a little bit about the law. Unjustifiable use of force is legal and lawful if you reasonably believe, I think we all probably already understand it by now, you reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial in ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing, in your mind, a reasonable, imminent threat, you don't have to wait. Let's talk about Sarah Boone and this unconventional form of physical restraint to block the attack of George Torres. What did she say? Salt tape. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that George Torres chose to get in the suitcase. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid and playing hide and seek. Which I guess when you get so drunk, that seemed like a thing. Zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen some of these videos and you're wondering why, but I think the evidence shows that when George is being videotaped, he's not going to do anything. If you think about that. When George is being videotaped, that's like her power. You know, Dr. Harper said that Sarah's words are her power. Sarah's words are her power. Physically, she's no match for George. Physically, she's no match. But that's her power, her words. When she gets a chance, when she gets a chance to have
deposition.
When you say that it was zipped shut, show us.
Are you talking about how I zipped it, or?
When you're done zipping
Like
it
a hole.
shut and he's inside of it, where are the zipper components? Where are the zipper components?
Just tell me one set.
I mean, it was the corner. I mean, the corner was
right here?
open. I mean, it's not. Yes, this one was already pre-pinched. Yes. From what I can remember. That's how he was coming with his hand out. It was like this from the corner part.
What a moment during the cross-examination of Sarah Boone. And what we have here, this suitcase, same exact dimensions. It was not an oversized suitcase, it was this suitcase. And what I've done here is I've
It just kind
of. Michael Brandon talked about perception of imminent danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from George, was because of George Torres. George Torres is responsible for her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase. She knows. The second video is played. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She used the bat to get him to stop trying to get out of it. Why would she do that? Why would she do that? I know what he's going to do. I know what he's going to do to me. I know him like I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself. She intentionally didn't unzip it to defend herself. Both of those are lawful under our law. She went upstairs. The dogs were upstairs. At some point she called her husband, her ex-husband, Brian Boone. We know that many times she testified, or somebody in court said she would often flee to her ex-husband's house sometimes. I believe that testimony came out from either Sarah or somebody. That sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were up there. She made a phone call. At some point she fell asleep. Passed out, fell asleep. We don't know. They had 2 big bottles of wine. Right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? You remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? They ended up over there by the dryer, and he was banging her back of her head on on the floor that had very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her, and that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her. You remember? Remember that? They arrested her. And she said, why? I was fighting back. You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement. Now, she didn't know the law. She's not a lawyer. She gets up the next morning. Brian's calling. Sarah's got to pick up Lucas at 3. Brian's calling. Eventually she walks down. She's looking for George. Where's George? It's quiet down there. Then she looks in the bathroom. She looks out. He's smoking a cigarette. He's on the computer. She sees the suitcase. And you can imagine.
Sustained.
She sees him in a suitcase. She can't explain. What does she do? What she do? She tries to get her fiance out of the suitcase. They're engaged